Boom. Hey folks, how's everyone doing? I hope you're having a good Monday. We are here to answer the burning question that's been on so many people's mind, which is, did Runkle manage to get a tan while in a very sunny place? And the answer to that is pretty much no, because I was wearing so much sunscreen. I was just making sure, because I always worry about burning, right? I always worry that I'm going to end up bright red and lobstery and not enjoy the rest of the trip. So I was wearing sunscreen all the time because, yeah, it was a bit of a thing. So, yeah, if you haven't been paying attention, I've been away for the last couple of weeks, and that is because I went on a vacation. Specifically, I went on Mrs. Runkle's bucket list vacation, and she was along, like we went together. I didn't just go for her bucket list vacation without her there. But she had, since she was a little tiny kid, she wanted to go and see the Galapagos Islands, and that's been something she always wanted to do. She was worried that they might close it to tourists or something like that, and so she's like, I want to go, like, before, like, because maybe they close it they've hinted about that, like, hinted about saying, okay, we're gonna cut off tourists and so forth. And yeah, so she was like, when can we go? And I was like, you know I think we can make this happen. I think that we can, I think that this is something we can do. I think we can make this happen. So let's do it. And so we went, and I don't know that it makes, like, the best financial sense, but we went because you know we gotta sort of do it while we can. And it was amazing. Like, this was her bucket list thing, and I was like, this really should have been on my bucket list too, because holy crap, it is absolutely amazing. Now, I have been told that I am awful at the grift, so I am trying to get better at that. So what we're going to do, I will share. I've got people going, you got to share stories, and it's like, I will share stories, but we'll do that with the. I've set a goal for sharing Galapagos stories with visual aids, and what I mean by visual aids is we've got. I've got, pictures and so forth that I can share with you guys and show you some of the cool stuff, because it was really something up there. So, yeah, I didn't get all the video I'd like to, like, all the stuff I'd like to have been able to get, because I forgot my GoPro. I forgot my GoPro here in Canada, and so I couldn't get some of the video and so forth that I wanted to get. And yeah. But we got a lot to talk about, and I don't know that we're going to get through all of the Karen Reed sidebars, because there's a lot of them. But we're going to start off by talking about Kelsey Fitzsimmons. I think it's a good place to start, and we might, depending on how we're feeling, we might go, and after that, we might do a lighter story about the about, like, Santa's committing crime. So, and I see people saying, has anyone heard from Rob? He's been missing in action for like a month. Rob is okay. Rob is fine. Rob is just buried in he's just buried in, like, trials and so forth. And so he's probably going to be away, he says, until like February. And So he will be back, but he's away for a bit. And that brings us to the sort of second announcement here, which is that I'm probably going to move my Monday shows to Fridays. I'm probably going to occupy Rob's time slot. And, I talked to Rob. He's okay with this. I'm not pirating his time slot. I'm just, moving it over. So that's probably what we're going to do. And I'm hoping to start that this week because I expect that we'll probably have more Karen Reed sidebar things than we've got time for today. So the plan is that we will, we're going to have stuff to talk about Friday. So the plan is we're going to do 2 streams this week, I hope. And Friday will probably be a little chill because it's the day after Christmas. But so some of you may be with family and some of you may be in other places and so forth. But we're going to do a little chill stream and yeah. So can we get bonus Monday sometime too? Probably, because sometimes I got other sort of stuff and so forth. So I'm also going to remind you guys, hit the like button on the stream if you can. That doesn't cost anything and it does help. And because YouTube does this thing, I'll tell you a little bit about the behind the scenes YouTubing. So behind the scenes, YouTube does this thing, which is if you take a couple of weeks off, YouTube assumes that you died. And so when you return to your time slot and are like, hey, I'm back, YouTube is like, okay, but we're not going to actually notify like anybody. So the numbers are always terrible on the first stream back from a time away. It is what it is. So hitting the like button helps because it helps getting YouTube to actually push that along. Oh yeah, my collar is yeah, thank you. Loving the pop the color vibe. That was me being slack. So yeah, all right, let's get going. And I see people saying they got the notification. That is excellent, but YouTube does things. It just kind of punishes you for YouTube punishes you for not being around, and it is what it is. But yeah, it just there we go. All right, so here we go. Where's the tie? Oh crap! So the tie got washed. It is downstairs in the laundry room. I gotta move the tie back. Rob is fine. The tie is fine. But yeah. Okay. So now if you're not familiar with this case, let me tell you a little bit of the background. Kelsey Fitzsimmons is a Commonwealth of Massachusetts police officer. And by all rights in the universe, Kelsey Fitzsimmons and I should be like not on the same side because I'm a criminal defense lawyer. So like we are not, that's not normally an alliance that you would see is police plus criminal defense lawyer. And what is it? The other thing is that, this is the Commonwealth of Massachusetts, which has some of the worst policing and the most crazy bullshit you've ever seen. So this is the same land as the Karen Reed trial. But she, in this particular case, appears to be the victim of the crazy, crazy stuff. Oh, this is a great question. Did Zora get fats again at the doggo jail? Oh my God, she did. Zora has some chunk, and and somebody who's saying, did the puppies forgive you? Yes, the puppies forgave us basically immediately. They were so happy to see us, and we love them. So now what happened is that Kelsey Fitzsimmons is involved in like a dissolution of her marriage, and in the process, well, not quite marriage, but you get the relationship, I guess. Um, and in the process of this, her guy went and got a restraining order against her, and basically to also get custody of their newborn. Now, in the course of this, she indicates that, what she says is that she got a hold of her firearm and was like threatening to harm herself. However, Jolene, my daughter's home from uni doing her virtual LSAT class upstairs. She takes it in April. Feel free to shoot me questions, but I'm sure she's going to kill it. So, what the police say, the Commonwealth police say that she pointed the gun at them. Now, those charges were not returned as a true bill by the grand jury. And this is interesting because the common phrase is that you can get a grand jury to indict a ham sandwich. So for the grand jury to be like, "Nah, we don't believe that. We we don't think that's the that's good enough to go to a trial," is really quite something, right? Because they will indict on all sorts of stuff. So that is not the point where I come in on this story, because I at that point was like, okay, that's like this level of fuckery. And I didn't really get into this story until the fuckery went up to here. So the what ends up happening is she has been shot. She was shot. And so in the course of being shot, she she sustained very serious injuries, right? That's what tends to happen when you get shot. And those injuries included like a broken ribs, various other things that made it difficult for her to comply with breath testing. She was able to do it, but she required a little bit of, she required multiple tries and so forth. So, yeah, she went to the judge to be like, "Hey, we need a variation of our bail because I cannot um I cannot, right? I just I'm having a lot of trouble with this." And the judge took great offense to this. And then on the judge's own motion, like the pro the probation officer didn't ask for this. The prosecution hadn't asked for this. The judge just was like, "Okay, we're just going to revoke bail and she can go directly to jail," which is to me insane. I should note there are no allegations that alcohol was involved in the actual incident. Not a single allegation. And there's no indication that says she's some sort of threat. Like, I can't see anything that says that Kelsey Fitzsimmons is going to be dangerous to anybody. So, but she got sent straight to jail, and she appealed that and got denied. And then she appealed that to the full panel. And that's what we're looking over today. Now, I see we've hit the goal. So I am going to interrupt to show you guys a thing. I just got to find the thing. Here we go. All right. Where's the video? Here's the video I want to show you. Now, I'm just going to note, I think you can slightly hear Mrs. Runkle in this one. Just a little bit. But let me show you this. Let me show you this video. Oh, I don't know why that thing is... Oh. Okay, it's struggling a bit for some reason. Let's watch it again here. Why is it struggling at the end there? I don't know. Maybe you guys can see it properly. All right. So this is something called a frigate bird. And frigate birds are neat creatures. They have this long... they got this long beak, right? They got this long... they're kind of dicks. So what I mean by that is that the frigate bird, like boobies and other birds, have oily feathers, so they can go diving, they can go fishing. And yeah, and I see it's locking up at the end. Let's try it again here just to see if it'll run through. There we go. All right, now we got the whole thing. So, the frigate bird is, there's tons of them, but they can't go diving. They do some fishing by, like, they'll float over the water and they'll try to, like, snatch fish out of the water that are near the surface. But frigate birds are a very special line of jerk, because they're not very good at like getting fish by that sort of means of fishing, right? It's not the greatest manner of fishing. So what else do frigate birds do? Well, frigate birds have a secondary adaptive strategy, and that strategy is crime. I don't mean like literally crime, because of course there is no such thing as bird crime. But what frigate birds will do is they will steal food from other birds. So they spend a lot of time looking for opportunities to like find another bird and steal from it because they can. And I actually got a video of that. I'm going to show you the video of a frigate bird being an absolute jerk. They are absolutely awful sometimes. Here we go. Here is the bird crime being committed by a frigate bird. So watch the frigate bird engaging in bird crime. We're just going to mute that just because. So what we saw there, what that was, is a booby feeding the baby, and the frigate bird swoops in to try to steal the food that mom is feeding baby. And so one of the strategies that the boobies use to avoid getting theft, you know, is that thing where, here, I'll pull it up again. You can see how mom, like, just absolutely gets like a lock in there. They do that because they know the frigate bird is going to try to steal the, steal the food. And yeah, so frigate birds are kind of neat. Also, that frigate bird I showed you the first time, this one here, if you're wondering why it's hovering like this frigate bird is on a mission. This frigate bird was engaged in some very specific birding activity. What that bird was trying to do is one of the groups that were with us had one of the people had sunglasses on her head, and that frigate bird was trying very hard to steal her sunglasses. It, for some reason, decided it wanted the sunglasses and was hovering above us. And it took like 2 or 3 attempts trying to steal the sunglasses before it eventually was like, I'm gonna give up, because she eventually clued in that like it was not gonna give up. And so yeah, she put her sunglasses in her pocket. But it was a bit clever there. It was a bit it was a whole funny thing. All right, so I've restarted the goal, and let's go back on here. Yes, my theory is that the bird was trying to engage in bird crime and figured the sunglasses would be a good disguise. So, okay, the petitioner, Kelsey Fitzsimmons, appeals from the judgment of a single justice of this court denying her petition for extraordinary relief pursuant to law. We affirm. And so what affirm means is that they affirm the original decision. So, yeah. Background. Fitzsimmons stands indicted in the Superior Court in Essex County on 1 count of assault by means of a dangerous weapon in violation of law in connection with an incident in which the Commonwealth alleges that on June 30th, Fitzsimmons, who is the North Andover police officer, was served by police with an abuse prevention order, and after deceiving officers about the location of firearms in her home, she drew a firearm, pointed at one of the officers, and pulled the trigger. When the firearm failed or did not discharge, Fitzsimmons allegedly attempted to rack a round of ammunition, during which time the officer twice yelled, "Kelsey, don't do it," or other words effectively instructing Fitzsimmons to drop the firearm. The officer then shot Fitzsimmons in the chest. Now, my understanding is that nobody else heard that, so yeah. Fitzsimmons was originally charged in the district court with 1 count of armed assault with intent to murder in violation of law and 2 counts of assault by means of a dangerous weapon in violation of other law. Upon a motion of the Commonwealth, she was held on dangerousness grounds pursuant to other law. On petition for review, a Superior Court judge likewise found Fitzsimmons dangerous and ordered her detained. On August 25th, Fitzsimmons was indicted in the Superior Court. The grand jury declined to indict her on a charge of armed assault with intent to murder, and instead Fitzsimmons was indicted on a single charge of assault by means of a dangerous weapon. A conviction of that charge carries a state prison sentence of not more than 5 years. And when they say not more than 5 years, she's not going to get 5 years, right? She's not gonna, whenever you see the 5-year, like the maximum, most people aren't getting the maximum unless we're talking about, serious stuff. We have seen, now the thing is that LawTube as a whole tends to cover more trials where you see, where you see maximums or closer to maximums. And the reason why is that we're covering stuff that is deeply messed up, right? We're often covering the biggest of the big trials, right? Everybody sort of flocks to the super huge stuff. And I mean, one of the things I thought about covering today, we might cover it on Friday, but I cut it for time, is like Rob Reiner was murdered, or at least killed. And the, one of the things that's been noted there is that Alan Jackson's been hired to run the defense. So everybody's like, ooh, Alan Jackson. And I do feel it is a little bit weird that we're kind of like following Alan Jackson around on trials. But the Rob Reiner thing, I'll cover it as we get some more information. I'm waiting for the full indictment to come out and so forth. The initial hints on that one are that we're probably going to be seeing like an insanity type defense, not not criminally responsible by reason of mental disorder, that kind of thing. And what is it? The thing that we're likely to see here is we're going to see that sort of unfold. But Alan Jackson is fun to watch. I do see that. And so, Alan Jackson is not a bad hire. He's a great hire for it because he's got no quit. He's a bit bombastic. He is, and he's going to fight. He's going to fight fight seriously hard on this one. So, we'll see. I mean, I don't think the insanity argument is crazy, but it is always a long shot. So, we'll probably cover that, and everybody's probably covering that one. And this I wanted to address. We're on a bit of a tangent, but that's how we roll here. I hate that I've seen people automatically hate on him for taking the Nick Reiner case. He's doing his job. Absolutely, he is. 100% this is the job. I'm going to say, as a defense lawyer, I don't always represent people that you would like. Some of the people I have represented are people that you would not like. Full stop. And the thing is that, in cases where you end up defending people's fundamental rights, often it's around people who you don't like. So, just to give a bit of an example here, I defended a case where the police searched a guy's trunk. And my argument, I ultimately lost on this argument. My argument was that that the police shouldn't have been searching this guy's trunk, right? And so my argument on this is purely every single person in the world, or at least in Canada, has the right to defend, to not have their trunk searched in these circumstances, right? And so my argument isn't just my client. My argument is also me and you and everybody else, the judge, right? My argument is for everybody. Now, it is kind of unquestionable that when they opened the guy's trunk, they found drugs. That part was not in dispute. In fact, we told the court, if you rule against me on the charter issue, the rights issue, we have nothing else to argue, right? If you rule against us on that, then the case is done. He's guilty. The only question is the rights issue, right? And so here's the other thing. I want you to consider the hypothetical, right? I want you to consider the alternate universe, right? Let's imagine that Turtle Boy never started, doing this, and Karen Reed never got the budget to look into the details on her case and to find all of those discrepancies, to start uncovering the butt dials and the weird searches and all of this shit, right? And she didn't have the money to hire, crash reconstruction people to be like, this is not a car crash, right? This is not a car accident. This is something else. He didn't die from being hit by a Lexus or any other vehicle. He died from something else, right? So, in that universe, that other hypothetical universe where that investigation never gets properly done, people would be bashing, Jackson and Yannetti and so forth for how could you represent such a terrible murderer? And there are still people doing that. And my take is, regardless of whether the client is guilty or innocent, it is important that they get a defense. Like when we watched the Hannah Gutierrez Reed trial, right? You remember that one. I was raging about Bowles, not because I think Hannah Gutierrez Reed is a good person. I'm not sitting there going, oh, she's a lovely person and she deserves to be out on the street, doing another film and, shooting more people, right? Or at least arranging for more people to get shot. That was not the thing at all. What I was saying is Bowles, do better, because she deserved a better defense than she got. And yeah, I mean, especially when he's sitting there, just watching her give her police statement, I was like, oh my God. So this is kind of an important, thing, right? So I don't care if, Nick Reiner is guilty or innocent with respect to my judgments of Jackson, because I think that it is important that even if he's guilty, he should have a very good defense lawyer. And if he ends up going to jail for the rest of time, I want to see him go to jail for the rest of time, knowing that he had the best defense possible, and that essentially that's how you know that bad people are in jail, is they got a good defense, right? So no shade on Jackson for taking the case, none whatsoever. That is what being a defense lawyer is all about. And okay, let's go back to Kelsey Fitzsimmons here, because yeah. And Kelsey Fitzsimmons has a good defense team, and no shade on them regardless, right? All right. So as it had in the district court, the Commonwealth moved for detention on the basis of dangerousness pursuant to law. In support of its request, the Commonwealth submitted a number of documents, including a police report detailing the June 30th shooting incident, as described above, as well as an affidavit and witness statements concerning the incident and the alleged events leading up to it. By the way, I hate supra. What supra means is it's Latin for above, right? But courts use supra and infra, and you'll notice supra, S-U-P-R-A, above, A-B-O-V-E, 5 letters for each of them. Just write like normal humans. Just say above. You can do it, courts. And while we're at it, you can stop with the comes now. Like, all right. So as well as an affidavit and witness statements concerning the incident and the alleged events leading up to it. In one such statement, Fitzsimmons' former fiancée alleged that at a party on June 28th, Fitzsimmons became intoxicated and violent, striking him multiple times and making suicidal statements. Oh, there goes monetization. And threatening statements concerning the couple's young child, all of which prompted the former fiancée to seek an abuse prevention order. He also allegedly warned police that when they served the abuse prevention order on Fitzsimmons, she would attempt to kill the baby, any officers involved, and then herself. Another witness statement indicated that Fitzsimmons had struggled with mental health issues, aggression, and alcohol abuse. The Commonwealth also submitted the affidavit of Fitzsimmons' former fiancée in support of the abuse prevention order, which echoed the above described representations and further represented that Fitzsimmons had been sectioned in the recent past. So sectioning refers to involuntary mental health. When they say sectioned, what they mean is like held involuntarily under a section of the code, right? Finally, the Commonwealth submitted an out-of-state criminal history record indicating that Fitzsimmons had been convicted in 2019 of a misdemeanor offense described in the document as intoxicated and disruptive. Yeah, intoxicated and disruptive does not, to me, say violent. It, to me, says somebody got drunk and was a jerk ass, right? Um, that's kind of drunk and disorderly is what it comes down to. In contesting the Commonwealth's motion, Fitzsimmons relied on a letter from a doctor affiliated with the hospital where she had received treatment after the June 30th incident. The letter indicated that while she was initially held pursuant to the law, she no longer met the criteria for involuntary hospitalization and was appropriate for outpatient care. So, additionally, Fitzsimmons relied on the report of an expert psychologist who concluded that Fitzsimmons posed no credible risk of harm to herself or others, and that the risk of harm from reuniting her with a child was all but non-existent. After a hearing on August 28th, the hearing judge determined Fitzsimmons to be dangerous, concluding that her release on personal recognizance would not reasonably assure her appearance at a future court dates or would endanger the safety of another person or the community. Nevertheless, they found that she could be released subject to conditions reasonably assuring community safety, including, as relevant here, the following. So here's the conditions that they put her on. Fitzsimmons was to remain in the custody of her mother and stepfather residing at their home. Fitzsimmons was to remain on 24/7 house arrest except for medical, court, or attorney visits, providing 48 hours notice to the Department of Probation in advance of any such visit. Fitzsimmons' location was to be monitored by a global positioning system, so GPS device, and she was not to be released until GPS monitoring was in place. Fitzsimmons was to abstain from alcohol and be subject to breath testing by Secure Continuous Remote Alcohol Monitor, SCRAM. And Fitzsimmons was to follow a treatment plan as provided by two specifically named doctors. The hearing judge concluded that these were the least restrictive conditions necessary to assure Fitzsimmons' appearance and protect others. No cash bail was imposed. These conditions, by the way, are very strict. Very, very strict. I have seen, Canada tends to be more releasey than other places. And just to put this into perspective, these conditions appear to be more restrictive than the conditions that were put on a terrorist in Canada, or at least an alleged terrorist in Canada, who, along with a couple of other people, is alleged to have taken an illegal firearm, like an illegally owned firearm, and gone about the streets on a Canadian street and basically gone hunting for women and Jews, and was released on less strict conditions than this. So, yeah, the puppies have opinions, but it's not actually about the decision. The opinions the puppies have are about the pizza that is being delivered. I think that's what that is. So, all right. For reasons not relevant here, the order was stayed until September 8th when Fitzsimmons was released subject to the above conditions. At a hearing held that day, Fitzsimmons filed a document styled as a medical notice, in scare quotes, containing representations from, and the styled as is, they're engaging in some mild shade, right? Some mild shade. And yeah. All right. So, what is it? Yeah. Containing representations from counsel about Fitzsimmons' health issues, including that she had trouble breathing as a result of her injuries. At the conclusion of that hearing, Fitzsimmons requested permission to remove the required GPS device for a surgery the following day, but failed to submit any evidence establishing that she could not wear the device during surgery. The request was denied. Now, I'm just going to note here, a lot of times bail stuff is not done on the strictest formalities of evidence. What I mean by that is that when when you're doing bail hearings, usually you aren't like calling witnesses. Usually you aren't, usually you're not doing all of this stuff. What you're doing instead is you are, a lot of it's done on representations to the court. Counsel says, hey, this is the case. So, and I mean, why would you need specific, like, why would you doubt the lawyers when they're like, she's going to surgery? All right. On September 10th, Fitzsimmons filed a motion entitled Defendant's Emergency Motion for Immediate Relief from Scram Order, in which she represented that due to her injuries, it was physically impossible to comply with the scram requirement, as performing the scram test caused her severe pain and dizziness. The motion attached affidavits to this effect from Fitzsimmons and her mother. It also attached an email message from a probation officer noting that when taking the practice scram tests, Fitzsimmons appeared to be in pain and struggled to complete them. But also, the probation officer testified in support of her. Right? He was like, this is not a problem. A hearing was held the next day in front of the same judge to address Fitzsimmons' motion. While Fitzsimmons' counsel described the request as a simple adjustment of terms, the hearing judge disagreed, observing that one of the reasons to ensure the safety of the community was for her to be alcohol-free. The hearing judge expressed reservations at being asked to amend her order with no medical evidence to support the request. Moreover, the hearing judge said that the probation officer's email message was not evidence because it was hearsay, which the law states is admissible there, and in any event that she gave it zero weight. She said she gave it zero weight because it was hearsay. But nevertheless, the court took testimony from the probation officer who authored the message, and without objection from the Commonwealth, he testified to the substance of the message. The court actually invited the Commonwealth to object, and they're like, no, we got no problem with this. Stating that when Fitzsimmons performed practice scram tests, he observed her to be in pain. Fitzsimmons' counsel offered the message a second time, at which point the Commonwealth objected on the ground that the probation officer had already testified to its substance, and the hearing judge excluded it. Okay, fair enough. You got the better evidence through his testimony. Fitzsimmons' counsel also purported to rely on the previously submitted medical notice to establish that Fitzsimmons had difficulty breathing as a result of her injuries. Also, there's a certain point where you can take judicial notice. Like, it is not a huge reach to think that somebody who has been shot might have medical issues as a result of this, right? It's crazy. So, yeah. So, general laws note that the hearing under this subsection may be reopened by the judge at any time before trial or upon a motion of the Commonwealth if the judge finds that one, information exists that was not known at the time of the hearing, and there's been a change of circumstances, and two, that such information or change in circumstances has a material bearing on the issue of whether or not there are conditions that will reasonably assure their safety. Fitzsimmons' counsel argued that it would amount to torture and cruel and unusual punishment in violation of the Eighth Amendment to the United States Constitution to insist that she remains subject to scram testing. Now, I should note, the judge really, really did not like the word torture. She lost her mind as soon as torture was mentioned. She's like, oh, well, we can't be torturing her, so we're going to detain her instead. The judge seemed to be punishing counsel for using that word. Fitzsimmons' counsel argued that it would amount to torture and cruel and unusual punishment in violation of the Eighth Amendment. Oh, right. He contended that alternatives for alcohol testing existed, and he suggested the appropriateness of urine testing. But he also acknowledged that it might step on the court's other order for house arrest because Fitzsimmons would have to go to a facility for that testing. I mean, Her having to go to and from a facility for testing is not like a big impingement there. Although he asked the court to consider any other alternatives, Fitzsimmons' counsel did not identify any others apart from the urine testing. And no reason why urine testing was not sufficient was provided. After a recess, the hearing judge concluded that the scram testing condition was necessary to ensure the safety of the community, and based on a review of the materials relied on by Fitzsimmons, including the testimony of the probation officer and counsel's representations, the hearing judge concluded that Fitzsimmons could no longer comply with that requirement. Consequently, the hearing judge vacated her prior order and ordered Fitzsimmons held without bail on dangerousness grounds. The hearing judge issued a written decision that same day in which she noted that Fitzsimmons' counsel failed to present any specific viable alternatives, without actually addressing why the urine testing was not viable. Here's the thing. This appeal decision very much is interpreting things in the most friendly way to the like lower court judge as is possible. And I think they are stretching things to do so. I look at this and I'm like, okay, yeah. It's a whole thing. So Fitzsimmons moved for reconsideration, asking the hearing judge to reimpose the prior conditions of release with urine testing in place of scram testing. This time, Fitzsimmons referred to a specific program whereby she purported that she could receive random urine testing at a location 10 minutes from where she was residing. The court was also super pissed that the tests weren't random. And, she's like, I ordered this to be random. And everyone's like, no, you didn't, though. It's not on the order. Like, it's not. So, her motion attached to an email message from the same probation officer sent to Fitzsimmons' counsel on September 10th, stating that the only alternative to scram testing is testing with this vendor. The message noted that through this vendor's program, on a day when testing was required, Fitzsimmons would receive same-day notice that she needed to test, and she would have to travel to one of the vendor's sites to submit to a test. Days after filing her motion for reconsideration, Fitzsimmons filed a supplemental exhibit, a letter from a doctor at the hospital where she had been admitted for treatment for her gunshot-related injuries. In the letter, the doctor wrote that Fitzsimmons' injuries, which included a gunshot wound to the chest and rib fractures, can cause pain that may persist for several months and could also cause chronic pain that can be exacerbated by movement, such as deep breathing. You know how hard it is to get a surgeon to write you a letter like that? You know how difficult that is? Really difficult. Surgeons are busy people, and surgeons also, how do I put this? A lot of surgeons kind of have a bit of a God complex. And so when you're like, when you reach out to a surgeon and you're like, hey, I need you to do this, they're like, hey, I need you to go fuck yourself. It's often very difficult to get surgeons to do anything, including like write a letter confirming that like somebody had their leg removed or something like that. They're just like, so vague digression, story time. At one point, I reached out to a surgeon and I just wanted him to confirm some very basic information in a form that I could use and submit to court. And the surgeon sent me back a letter, and the letter was detailed about how I could go F myself, essentially, getting into like serious specifics about how I could F myself because, that's not quite the words he was using, but, he sent me a very detailed communication about how important he was and how much of an imposition it was for me to ask him to write a letter and, all of these things. And I was just like, you could have actually written the letter that I asked you for, and it would have taken less time than you spent being a jerk about it. So, why are you doing this? Why not just write me the letter? Yeah. It was a whole frustrating thing. So, but they got a letter from this guy. They got a letter which confirmed this. And yeah, on September 16th, the hearing judge denied the motion, declining to reopen the hearing pursuant to GL, to the law, or otherwise reconsider her ruling. In a written decision, the hearing judge observed that the information submitted in support of the motion was known to Fitzsimmons at the time of the September 11th hearing, pointing to the fact that the attached email message from the probation officer describing the urine testing program at issue was sent to Fitzsimmons' counsel the day before the September 11th hearing. Moreover, the hearing judge observed that, as the message described, the request to employ this particular urine testing program, which was the only alternative, would require Fitzsimmons to travel to one of the vendor's sites for all tests, and the same-day notice provided through this program would preclude the 48 hours notice to probation required for the limited exceptions to Fitzsimmons' home confinement. Who the fuck cares? The 48 hours notice, like, you could say 48 hours notice for all, all leaving except for urine testing. Right? And the problem is you can't have it both ways. You can't have it that she needs to go and do random testing, which the judge was losing her mind about, or 48 hours notice. If you want 48 hours notice, you got to have specified testing times, right? That makes sense. Or if you want it to be random and a surprise, then you can't have 48 hours notice because it's a fucking surprise. Right? It's like, I can't give you 48 hours notice of when somebody's going to throw me a surprise birthday party because I don't know when that is. God damn it. This is so bizarre to me. So, the written order stressed that the requested alternative would undermine the importance of minimizing the number of times Fitzsimmons was allowed to leave the residence. On October 2nd, Fitzsimmons petitioned, and here's the other weird thing. They're like, we're concerned that she might have mental health issues. You know what's really the best approach to managing her mental health issues? Keep her locked at home with no healthy interactions. Bizarre. Okay. On October 2nd, Fitzsimmons petitioned a single justice for extraordinary relief. In her petition, as she done below, she contested the Commonwealth's version of events, but admitted that she took out a firearm during the June 30th encounter with police and that she raised it to the side of her head in a half-hearted attempt to inflict self-harm. The petition criticized as intemperate the behavior of the hearing judge at the September 11th hearing, and it asked for relief from the order detaining Fitzsimmons. I think intemperate is a fair description of it. Specifically, it asked that the order be vacated and that the single justice address bail de novo and release Fitzsimmons on personal recognizance with only the conditions of a stay-away order issued not on dangerousness grounds, but instead pursuant to other sections. The petition also requested that the hearing judge be recused from further proceedings in the Superior Court. So they wanted to kick the hearing judge off the case, right? Which, yeah. In support of the requested relief, Fitzsimmons argued that the single justice, that that the hearing judge erred in declining to employ an available common alternative method of alcohol testing, which was a less restrictive alternative to incarceration. Single justice denied the petition without a hearing, concluding that the hearing judge did not err or abuse her discretion. So she now appeals. All right, this is a 10-page document. We have gone to page 7, and everything up until page 7 is just recap, right? So, discussion. We review the single justice's denial for clear error of law or abuse of discretion, and we must also consider the propriety of the underlying bail order. Okay. Where the Commonwealth is properly moved pursuant to 58A for pretrial detention on dangerousness grounds, which was argued that they didn't, a hearing judge may order pretrial detention only where he or she finds by clear and convincing evidence that no conditions of release will reasonably assure the safety of any other person or the community. On the other hand, where a hearing judge determines that conditions of release will reasonably assure the appearance of the person as required and the safety of any other person in the community, he or she shall order pretrial release subject to the least restrictive further condition or combination of conditions that will do so. Fitzsimmons contends that the hearing judge found pursuant to the law that the community's safety reasonably could be assured through the imposition of certain conditions of release, and that when presented with Fitzsimmons' request for urine testing in place of scram testing, the hearing judge was required to make that substitution because it was a less restrictive alternative that nevertheless would reasonably would assure the safety of the community. We conclude that the hearing judge did not abuse her discretion in denying the request and detaining Fitzsimmons. After the August 28th dangerousness hearing, the hearing judge appropriately imposed the conditions restricting Fitzsimmons' release, including the scram requirement. The evidence presented at that hearing, described above, justified those conditions. Although Fitzsimmons argued that alcohol did not play a role in the June 30th incident, the materials submitted by the Commonwealth at the August 28th hearing indicated that she struggled with aggression and alcohol abuse, that she'd been convicted of an offense apparently arising from intoxicated and disruptive behavior, and that she was recently alleged to have become violent when drinking alcohol. Now, all of this makes the question of, like, why was she a police officer in the first place, right? The police certainly found that she was okay to be, equipped with a firearm. It's being reported Kelsey will be having an emergent hearing tomorrow at 2 p.m. Yes, we're going to cover the filing. We're going to cover that. So the hearing judge properly considered these materials when imposing conditions necessary to protect the safety of the community, conditions that included abstinence from alcohol monitored by scram testing. Moreover, the hearing judge appropriately concluded that Fitzsimmons could no longer comply with the previously imposed condition of scram testing. Fitzsimmons does not contest this finding and indeed has relied on her representations that compliance with scram testing was effectively impossible for her due to her injuries. In sum, the hearing judge did not err or abuse her discretion in concluding that where Fitzsimmons could not comply with the least restrictive conditions necessary to ensure this, she should be detained pretrial for dangerousness. We further conclude that the hearing judge did not abuse her discretion in denying Fitzsimmons' motion for reconsideration on the ground that the alternative to which Fitzsimmons pointed, that is urine testing, would not reasonably have assured the safety of the community because it would have interfered with the condition of home confinement. I mean, how is the home confinement that important that she can't go from her house to the testing and directly back at a time you know when it is, right? All right. So they say, indeed, Fitzsimmons' counsel had acknowledged that the September 11th hearing that urine testing might step on the court's other order for house arrest, and Fitzsimmons' motion for reconsideration specified that the urine testing program she requested would require her to travel 10 minutes from her house for any test. 10 minutes! Like, you spend 10 minutes there. So 10 minutes to go there. You spend 10 minutes getting the test done, 10 minutes back. She's gone for half an hour a day. In denying Fitzsimmons' motion for reconsideration, the hearing judge properly concluded that community safety required minimizing the number of times Fitzsimmons is excused from house arrest. It seems bizarre for me there. So they have this here. What is it? Fitzsimmons also asserted error in the conduct of the September 11th hearing. She contested the exclusion from evidence of the email message in which the probation officer described observing Fitzsimmons in pain during practice tests, but the probation officer testified on this point without objection from the Commonwealth, and the hearing judge ultimately credited that testimony. The message was therefore cumulative of the testimony, and the hearing judge did not err in excluding it. In addition, Fitzsimmons contested the hearing judge's finding in her September 11th order that Fitzsimmons did not submit medical evidence. Fitzsimmons asserts that the medical notice was medical evidence, but this document contained only representations from Fitzsimmons' attorneys, and in any event, the hearing judge concluded, consistent with these representations, that Fitzsimmons was unable to comply with scram testing. In sum, Fitzsimmons represented that she could comply with the requirement, and the hearing, or could not comply with the requirement, and the hearing judge so found. You know what I'm not seeing here? You know what I am not seeing at all? I'm not seeing anything saying that they actually listened to the recording. And listening to the recording, to me, is a key thing here. So Fitzsimmons also argued that the hearing judge violated the Americans with Disability Act, denying her request for alternative testing, which she classifies as a request for reasonable alternative accommodation. And Fitzsimmons provides no citation for the proposition that whereas here the hearing judge acted within her discretion, including that the requested alternative would not reasonably protect the public safety, Title II would nevertheless require its imposition. Okay. So, yeah. And we're not going to cover this footnote because it basically says there weren't any alternatives. So, in addition, Fitzsimmons asserted that her return to custody pursuant to the September 11th order was governed by law rather than by other law. The single justice correctly rejected this argument, observing that the hearing judge was authorized by law to reconsider the order imposing the conditions of the release, which is what the Fitzsimmons motion had asked her to do. Reconsider the conditions. They're required procedurally to give notice where there's a risk that she be reincarcerated. And she wasn't given that notice. That was part of the argument that is not being considered here. This is insanely frustrating. Conclusion: for all the foregoing reasons, we conclude that the single justice did not err or abuse her discretion in denying the requested relief pursuant to law. Okay. What is it? They also refused to remove her from the case. And yeah. All right. Now, I believe, on information and belief, I believe that there is currently pizza available for me. And I would like the pizza. So therefore, I am going to put you guys on a brief, I'm just trying to find a good video to leave you guys with for a second there while I go and, while I go and grab some food. I just need one that's like a couple of minutes long. And a lot of my videos are like 10 seconds long because I was thinking I could make these into swoops. And so I haven't actually gotten around to making them into swoops yet. That's going to be a project, but yeah, I need something with enough time for me to scramble and get a pizza or a piece of pizza and come back. Let me just see here. I thought I had one that's like a couple of minutes long. Where is it? So many of them are just like 30 seconds. And I'm like, I cannot run that fast. That one's no good because it's just, I got to delete that one. And I can't actually give you guys like a playlist, so that doesn't work either. Where's... Might have to run fast. All right, I'm going to put a video on, and if it's too short, then yeah, we'll just, that'll be what it is. So 1 second here. Let's see. How about, how long is this one? Oop. Is it actually going to add to stage? There we go. Oh, this is real short. Dang it. I thought, can I set it to replay? Is that an option? Okay, we're going to mute that. I'm going to, there's legs randomly in this one. All right. So this is not the best video because it's taken on a cell phone through a bag, but yeah, I'll be right back. All right, we're gonna kill the music there. At some point, there's a sea turtle visible in this thing, but I gotta cut that down. Okay, so yeah, this case is intensely frustrating because, quite frankly, she should be released. Like this, this is totally a thing. Also, I owe you guys another Galapagos story, and you know, and with visual aids. So let me find a good video here. I'm just going to add one. I'm gonna remove that. Let's see. I didn't eat pizza already. I got pizza. Let's see. Where is that? I'm just trying to make sure I pick one that is okay. Here we go. So, Mrs. Runkle did a lot of research before we went on this trip. Like, tremendous amount. And one of the things she did research into was she wanted to figure out the absolute best time of year to go. She's like, I want to see the best possible, you know, stuff when we go. And I want the weather to be nice. I don't want it to be the rainy season. I don't want it to be super sunny. I want it to be the perfect time of, you know, perfect time of year because I, you know, this is the trip I've always wanted to take. And so I want it to be, I want it to be ideal. And she really nailed it because we got there and it was, some of the animals were in mating season, but a lot of the animals, including the birds, were in, like, they had little newborns, they had babies, they had eggs, they had stuff like that. So this is a baby booby. This is a booby, and it is right now doing some important practice. So here we go. So what you see it doing there is they're not like they're really good flyers. They're really good once they get into the air, but they actually are kind of they're kind of ungainly when they're taking off. They're not the best at taking off like from the ground. And so what they do is they actually find a place where they've got like a runway, and they sit there, and like the adult birds will they will like run up into this runway, but they also want the wind to be in their face, and the winds are actually pretty consistent out there, so they find like places they take off. But the babies, the little ones, this is a little baby bird, and you can tell it's a baby in part because its feet have not yet developed color. That's something that happens when they're older. But the babies, the juveniles, they practice. So before they learn to fly, they he's sitting there and he's learning how to fly, right? He's practicing, getting those wing muscles, bulked up. He's and it's really cool that we got to go there and see the birds doing its little it's like their practice things. So we got to see birds like learning how to fly. I think that this one is actually a Nazca booby. So there's 3 kinds of boobies. 3 kinds. And let me find pictures to show you the 3 kinds of booby, because there's 3 kinds and we saw all 3 kinds. Okay, so there's one. I'll show you that one. Let me pull up another one here to show you. Oh yeah, this is a good one, I think, to show you that. No, maybe I can find a better picture. Let's see. I'm just trying to find a good one for this other kind of. Oh yeah, there we go. That's the one. Yeah. So there we go. That's the second kind. And then I got to show you the third kind, because we got 3 kinds of boobies here. And I want to make sure that I properly show you all 3 kinds, because they are all pretty awesome. And it was cool that we got to see them. And I want to share them all with you guys. So, okay, here we go. All right. So we'll take this down. We will show you guys this first one. And I'm going to stop screen. We're going to share screen. It's going to be... All right. So this is a Nazca booby. And you can tell because they've got the very distinctive white and black coloration. That's sort of what differentiates it. And yes, chat, we can be children. Like that's allowed here. I get it. And right next to it is the baby, the juvenile. And they look so dumb when they're young. So dumb. So that is the first kind. That is and yeah, the next kind that we're going to see here is pups have some opinions. All right, here we go. This is a red-footed booby. And you can't always tell that they're red or blue from their foot color, because believe it or not, their feet are they're not born with the red feet and blue feet and so forth. They actually they develop that from what they eat. So they eat stuff, and then the stuff has pigments, and those pigments end up getting extruded in different parts of their body. So that's how they end up with the red feet, and in this case, the blue beak. So if it's got gray feet, the way you can tell is that the red-footed boobies like trees. They like to go up and stay in trees. So if you see a booby that's in a tree, it's a red-footed booby. And one more. And this one is perhaps the dopiest looking. This is a blue-footed booby, and you can tell not just because of the feet, but also because they walk around on the rocks. So we saw all three kinds of boobies. They are absolutely dopey looking on the ground, but and they're dopey looking taking off. They're dopey looking. They're dopey looking when they what do you call it? When they land. But in the air, they actually look really impressive. And what I mean by that is they're actually quite agile flyers once they actually get moving. And they also are really good divers. You can see if you're on the Galapagos, they'll talk about bird beaks a lot, because that was what Darwin was interested in, about the evolution of birds through the beaks. And yes, I'll talk about Tronco, but we're not going to talk about Tronco today. So we'll talk about Tronco another day. I see people asking about that one. So they will fly, and they'll kind of fly and hover and hover and hover. And then they dive down like a knife stabbing into the water. And it's super impressive, because they just will like shoot down, and they'll come up with a fish. And it's like, wow, that is super impressive. Okay, so let's catch up on super chats, and then we're going to cover the next saga in the Fitzsimmons thing, because it's not done yet, and we're going to set a new goal, which is more Galapagos stories, because people were like, you got to tell all the stories, and we're not done. So Pop Princess says, I'm so glad you're back safe. Me too. It was a good trip. The only downside to the trip was I got seasick a bit. I did get some, because we were on a boat. And it's not like a huge cruise ship. It was a little tiny ship with like eight cabins, right? And so during the so basically the schedule each day was like 8 a.m. breakfast, 7 a.m. breakfast, 8 a.m. go and start doing things. And most of the time that was stuff like, go for a hike, that kind of thing. And then, so you go for your hike, and then then there'd be snorkeling, and then lunch, and, all of that. And then in the evening, in the evening, you would, I appear to be bleeding a bit. That's all good. in the evening after, like, you'd have dinner, and then immediately after dinner, they would start the ship up and take it to the next place. And when the ship is moving at high speed, it starts rolling. And that rolling motion, I got really badly seasick the first night of that, which wasn't our first night on the ship, but the first night that we had like some rocking seas, I got really seasick. And thankfully, I was able to control it with some gravel, and it worked out. But it was a rough night. Me and Mrs. Runkle both had a really rough night the first night. And yeah, somebody else threw up off the boat. So yeah. We did not need to resort to suppositories, thankfully. So yeah. So glad you're back and looking forward to stories and photos. We got stories and photos and some videos. At least you remembered what day of the week it was. Yes, I kind of lost track of time while I was away. Giraffe Gal, thank you so much. Vez from Quebec, story and happy that you got some vacation. Yeah, I'm bad at that. What a fun vacation. Love having you back. Thank you so much. Good to be back. Joy W, glad to see you're backing. Stories as many as you can. I have stories. Welcome back. Thank you. Linda Santiago says, glad you had an amazing time. I really did. It was awesome. So many stories. Tortoise and finch stories. Ooh, we can tell some tortoise and finch stories. I don't know how many pictures of finches I got because often they're kind of small, so they're hard to get good pictures of. And Hunk Banana No, thank you so much. Where's that thing? Here's the thing. Took a bite there. Thank you for 20 gifted memberships. Really appreciated. Joy W says, so glad you're back. Mondays aren't the same without Monday Fun Day. They'll probably be on Friday, although I may do bonus streams on Monday as well. So Merry Christmas, Hannah Kwanzaa, everybody. Thank you so much. Hopefully nobody's offended. Mildred Katie, we don't tan. We bake to a glossy lobster red. Oh, I just burn. I just catch fire. Story time. We'll have stories. Amy's Positive Pathways, welcome aboard. Phoenix Fire, thank you. Patricia 1958, thank you so much. I nicked myself with a razor and it's bleeding pretty good. Joanna Laura, glad to see you back. I live in Essex County and the police stations you worked at has lawsuits by female officers for treatment of women unfairly. Does not surprise me. So frigate birds or emo seagulls, kind of. Welcome back, Runkle. You were missed. Thank you so much. I missed you guys too. Merry Christmas. Happy New Year. Merry Christmas. Raceland C. My dad retired to Cuenca, Ecuador. So you were located much closer to him than I have been in the last 6 to 7 years. It's not a bad place to retire to, I don't think. So yeah. I will horrify you guys a little bit. If you go to Ecuador, you will see, if you go to a restaurant and it serves Ecuadorian food, which, you know, you should, because you should definitely like go to see, but be aware of something you'll see on the menus. Be aware. Because like every restaurant had guinea pig on the menu, like every single one of them. And yeah, well, not every single one of them. There were some touristier places that like dropped that off, but yeah, they tons of them had guinea pig on the menu. And yeah. Bird crime? No. Pigeon business? Yes, with boobies. For more Galapagos picks and stories, so glad you're back from your amazing adventure. It was fantastic. Galapagos picks, please. We'll have more. Defending the rights of the worst among us is defending the rights of all of us. Welcome back, and thanks for doing what you do. Thank you. Hey, Runkle, can't wait to see more picks. We got lots of picks. Are you planning to look at the Delphi appeal at some point? No pressure, just curious. Also, Galapagos pictures. Yay. I didn't follow the trial. I will probably have a look at the appeal documents just to see. And yeah. People are asking, did I try guinea pig? We'll we'll have to leave that to your imagination. So, yay, missed you, Mr. Runkle. Hope you had so much fun. I had a lot of fun. Living like a cat. Welcome back, Ian. Thank you. Welcome home, Runkle family. I'm enjoying a Canadian beer tonight, La Fin du Monde. I am also enjoying a Canadian beer. It is from Babe Brewing. It's their Tangerine Dream Lager, and it's got a piglet on it. So, yeah. They are not a sponsor. I'm just, yeah. What do you call it? MA courts generally seem happy to deny bail for serious allegations, even when a flight of recidivism seems unlikely. So how did Karen Reed get bail? I think she probably has a better defense, or a really good defense. Yeah. If interested, I wrote a Melanie Little inspired Massachusetts Free Kelsey song to help raise awareness, help her defense. Yeah, sure. runkleofthebailey@gmail.com. Shoot me a message. My oldest wants to know, did you see sea iguanas? Yes. So the sea iguanas are marine iguanas, and the marine iguanas are kind of cool because the marine iguanas eat eat algae, and some of the iguanas, maybe I can pull up an iguana picture just as a bonus here. What is it? Some of the iguanas, what do you call it? They dive, and other iguanas, but only the biggest ones dive. The other ones just kind of, what do you call it? The other ones just wait for the tide to go out and then eat the, the stuff in the intertidal zone. So that's a marine iguana, and they are everywhere, and they're good size. They're like big iguanas. I didn't get to see any that were like underwater, but I did get to see them like running around and so forth. Motion for this bird's name to temporarily be removed from the no words list. I feel too English calling them bobbies, or unless it's banned by YouTube. It's YouTube's end. I can't do it. So, will you cover the Tronco shooting in Welland, Ontario? At some point, probably, but yeah. Listening to Runkle explain the different types of boobies. I'm a mature adult. Staff laughing at avian biology. We can laugh. UK now bans birds for their stabbing abilities. Oh, God. Jaded for Justice, thank you for joining up. Do we need more birds? YouTube won't let me say the funny words in our lives. Yes. Glad you had fun on vacation. They're really awesome. I'm so glad you took such a great vacation. It was fantastic. Try green apples next time for seasickness. I will probably stick to the medication because the medication did it in a really good way. For more Galapagos picks, thank you. Awesome trip. Thank you for entertainment in hospital. Thank you. Good to see you. Mondays weren't fun without you. Well, thank you. Pet store during the day, restaurant at night. What is it? All right. Can you give us an idea of what it costs to take a trip to the Galapagos and any cost-saving tips? Mrs. Runkle did the booking. There are more expensive and less expensive trips, and I mean, part of it depends on how far you go. I don't know what all the detail. Turns out iguanas will think your toes are fruit if your nails are painted red or yellow. Whoops. That's the other thing that I really liked about the Galapagos and Ecuador is there was lots of fruit available, but also fruit juice. And the thing that was really nice is that the fruit juice was all unsweetened. And you might say, well, isn't most fruit juice unsweetened? God, no. And so when you go and get like a mango juice, you get like a thick mango juice with lots of pulp and so forth. And it's not very sweet because it's just as per the fruit. And it was so good. I was such a fan because I don't really like really sweet stuff. I am much more of a savory person. And I'm just like, I wish I could get that more. I'm gonna probably end up buying buying mangoes and just yeah. All right, so let's go and have a look at no, which this one. And I got to actually pull it up. Here it is. I drink cola because it's got caffeine in it. So, yeah. All right. So, Commonwealth of Massachusetts, Commonwealth versus Kelsey Fitzsimmons. This was just filed. This was really recent. Just filed. Defendant's motion for an expedited hearing and an in-person writ of habeas corpus to issue due to change in circumstances. So, and I'm seeing people say swoop. We can do a swoop. Swoop. So, now comes the defendant. Now comes is better than comes now, but I still hate it. Now comes the defendant, Kelsey Fitzsimmons, through counsel and respectfully moves this court on an expedited basis to reopen the dangerousness determination pursuant to law and immediately reinstate the prior conditions of release previously ordered by this court. Further, Ms. Fitzsimmons requests for an in-person writ of habeas corpus to issue returnable for tomorrow, December 23rd. This court previously found that conditions of release existed that could reasonably assure the safety of the community and ordered Ms. Fitzsimmons released under conditions, including GPS monitoring, house arrest, abstinence from alcohol, etc. Ms. Fitzsimmons was remanded to custody because she was physically unable to comply with scram breath testing due to acute injuries from a gunshot wound to her chest. Significant time has passed since Ms. Fitzsimmons' remand to custody. During that time, her gunshot-related injuries, including rib fractures and lung trauma, have healed sufficiently to allow her to breathe into the alcohol testing device. Ms. Fitzsimmons has been tested in the medical department of the correctional facility and is now able to exhale at the average force for an individual with her demographics. So see medical report from Western Massachusetts facility filed herewith. Ms. Fitzsimmons is now physically able to comply with scram breath testing without physical incapacity or resultant injury. This constitutes a material change in circumstances and directly resolves the sole condition the court previously identified as preventing continued release. So, Section 58A expressly permits reopening where a change in circumstances has a material bearing on whether conditions of release can reasonably assure the safety of the community. The condition that previously rendered release not possible, scram compliance, no longer exists. Further, both Superior Court and the Supreme Judicial Court have noted that such a motion is appropriate if there's a change in circumstances. And so, certificate of service, we don't care about. And here they have the thing, treatments, med alert, patient giving Voldine volumetric exerciser. Patient no distress seated when this writer arrived, met with patient. She was able to use the device. She was able to perform deep breathing and was able to mark the volume of air inspired with each inhalation. Mouthpiece was used correctly as she was able to make a seal around the mouthpiece. 3 to 4 inhalations were performed. Volume recorded was 2100, 2500, 2300, 2300. Patient is 29 and 63 inches. Predicted volume for a 25-year-old is 6'4" is 2450. 30-year-old 62 inches is 2200. 30-year-old 64 inches is 2400. So she's right in the area, right? So, yeah. All right. Now, here's the thing. She should be released on this motion because the court was like, she can be released if she can comply with scram testing. And now they're like, she's healed now. She can rely on scram, or she can do scram testing. I have this niggling little feeling at the back of my head that says that this judge might just be pissed off enough and peeved enough. Now, what I hope is that the judge goes, okay, I won. I won. They're going to do what I asked. So she gets released again. You know, I get to be the big dog. But I have this concern, the back of my head, that says maybe this judge is going to say, nope, not going to do it. Not gonna do it. Nope, 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 not gonna. And now here's the thing. If they do say, I'm not going to release her on the same conditions as before, then I think that there's a very good argument for, for this to be essentially, or for the argument that that at that point the judge is not behaving reasonably and instead is behaving entirely unreasonably. And so I hope the judge is smart enough not to fuck around on that. Because if the judge says, I'm not releasing on this, I would be saying, look, she's got to be removed. It's clearly fucked up, right? And here's the thing. I don't think she's being paid off, right? I don't think that's the case. I don't think that's what's going on. I think this judge just got a bit salty about, like, oh, you say my order is going to be torture? Fuck you, right? That's kind of what I think the judge is. And I think the judge and defense counsel are kind of in a bit of a personality conflict right now. So it happens. You get judges who are just like, I'm pissed off, so therefore, I'm going to do what I want to do, and, and I'm going to show you that I'm the big boss. And I mean, I hate it. I don't like it, but it happens. And yeah. All right. Now, I think I set another goal here. The goal that we've got going right now, somebody was asking me what my favorite of the animals was that I saw. If we hit this goal, I will show you my favorite of the animals very shortly. Okay. So let's dive into, do we need a break? Do we need a break from serious stories to talk about a less serious story? Because we could cover a bit of a lighthearted story if people want. But if people are like, get to the sidebars, we can get to the sidebars. Are people like, we need a diversion? Okay, we need a less serious one. Okay, let's do that. So I'm going to show you a less serious story. And before I tell you this story, I'm just going to note, I have an alibi. I was not involved. I've got an alibi. Okay, here's the less serious story. Thieves dressed as Santa and his elves steal $3,000 worth of goods from Montreal grocery store. I have an alibi. I was not one of the elves. So, and then they got a picture here which shows Santas and elves are stealing things. So what happened in this story is that several people dressed up as Santa and elves, and they went to a grocery store and they loaded up a whole ton of food, and then they just fucked off. They left. So in this like coordinated heist, they stole a whole bunch of food from a Montreal store. The food in total was estimated at $3,000 worth of food. And the group that has claimed responsibility for this, they've issued a statement saying, we are responsible, is a group that calls themselves Robins of the Alleys. So they're literally like a Robin Hood reference. So what did they do with the $3,000 worth of stolen food? Well, they put out a statement on Instagram and they said, okay. They said, and they say, a handful of corporations are holding our basic needs hostage. They continue to stifle the population, siphoning off as much money as possible simply because they can. For us, that's theft, and they are the real criminals. So, what did they do with the food? They placed the food under a Christmas tree out in public for people to go and collect. So they literally robbed the store and then gave the food to the poor. Now, they didn't engage in any violence. I mean, the thumbnail is a bit of clickbait because the thumbnail shows a Santa with a gun, and they did not have guns. They did not engage in violence. And they had a very Christmas-themed theft, right? They had a very, it was Jingle Bells burglary, if you want to. So, anyway, they stole the stuff and they gave it to the poor. So, here's the thing. If they are eventually caught and convicted, which is a big maybe. Somebody says, what store did they take from? I think it's called a Metro. If they're caught and convicted, I expect that the penalties they get would be pretty low at the end of the day. But the spokesperson for the store was like, we remind everyone that crime is bad. Please do not crime us. Thank you. So there's that. And, please do not crime us. But I mean, if they're ultimately convicted, I suspect that these people would get a fairly minimal sentence. I would very much expect that they would get like a conditional discharge. So now I see somebody saying they'll be caught. Maybe if they're smart and if they have used sufficient care with their digital footprints, because that'll be the Instagram account will be the weak link. But these are actually really brilliant costumes because when they go the costumes include an effective disguise in that you've got you've got the beard and the hat and so forth. So you're all disguised. You got gloves, so you're not leaving fingerprints. You're probably not leaving DNA behind or anything like that. Everything is all covered and whatever else. And the instant they leave the store, well, if you catch on video, like 3 blocks away, like a Santa in a Santa costume near Christmas, it's going to be real hard to say that's the same person. So, I mean, they're actually, I'm not saying go commit crime, because don't, but it is a fairly clever way to do it. They actually were pretty sensible about it. So, I'm like, all right, I'm kind of impressed, and the thing is, I suspect people are going to get caught because ultimately I suspect that the weak point is going to be the Instagram account and that they're going to find somebody like through that and they're going to catch people And then once they catch one person, they'll probably get that person to roll on their friends and all of that. Everybody thinks it's easy to get away with crime. Typically, it's not so much. But I'm like, huh. So we'll have to see. But it is kind of a lighthearted story. And again, I have an alibi. I was not one of the elves. I was, what day did this happen? I'm just checking. December 18th. I was either in, like, so the story was reported December 18th. I was either out of the country or I was in Edmonton. So it was not me. Not me. All right. So let's go to sidebars. Because yeah. All right. Let's see. There's a lot of pages. We're not going to cover. So what got released is the full transcripts. And we're not going to cover the full transcripts because you watched the trial. The only thing to see at the trial was this. And so that's what we're going to check. And some of the sidebars are less interesting than others. I thought about going and only covering the sort of most explosive ones, but I think it's worthwhile looking at all of them. So let's swoop. Okay, so these sidebars, some of them are more momentous than others, and there are some sidebars that are covered by redaction things. And the redaction things basically are the judge said that they would redact anything that had jurors or jurors basically in any way because, yeah, and I don't think that's unreasonable. I don't think that's an unfair redaction. I've seen some people online say, oh my God, why is she redacting things? I don't think it's unreasonable for her to redact the jury stuff. Like, I don't. So, no problems there. But we'll cover some of this. We'll cover the sidebars and yeah. All right. So this is right after opening statements, this first one. So the defense has just concluded their opening statement, and Ms. McLaughlin says, Your Honor, may we approach you at sidebar? She's objecting to the defense opening. So, court, yes, jurors, when we come to sidebar, please feel free to stand up and stretch. So, Ms. McLaughlin says, Your Honor, the Commonwealth would object to defense counsel's opening. Contrary to rulings of this court, they opened with suggestions of a third-party culprit. Twice, defense counsel represented that Karen Read was framed and that she was ambushed and that someone else did it. The Commonwealth would like to object, given the ruling of this court, that there would be no third-party culprit claims within the openings. And the court says, well, what do you want me to say? Just say openings are not evidence? I remind you, openings are not evidence? And the clerk says, sorry, one of the jurors needs to go to the bathroom. And the court's like, okay, yeah, that's fine. Jurors, off you pop. Go away. And then, so the sidebar continues. Ms. McLaughlin says, yes, so if you could note the Commonwealth's objection and give a limiting instruction reminding the jurors that openings are not evidence. And the court says, okay, Mr. Yannetti. And Yannetti says, so I don't think that I did anything improper. I think that I couched it in terms of the lack of investigation that they did, and I did not name any third-party culprit at all. But I have no objection to the court's solution. And I agree that Yannetti was not off base. I agree that he did not do anything wrong here. Runkle, you said it wrong. It's sidebars. Fair. But what do you call it? Yeah, that podcast is a nightmare. I have no idea why they're doing that. So the court says, okay, you did a decent job, but there were a couple of times that you pushed it. All right, I will instruct them when they come back. What I was going to say is we'll take a 15-minute recess. So who's your next witness? Do you have more than one for now until 1 o'clock, or do you have just one? And so that's Paul O'Keefe. They come back, and when they return, they just go directly to Paul O'Keefe. So they come back, and they promised the defense they'll give a limiting instruction, and then it just goes directly onto Paul O'Keefe, with Judge Cannone not giving them the Commonwealth is like, we want a limiting instruction. Yanetti's like, okay, that's fine. And she's like, I'm going to give the limiting instruction. They come back and she's like, I forgot. She saw a shiny thing. She got distracted, and I get it. Right. I get it. But still, I'm surprised the Commonwealth didn't be like, hey, Judge, you were going to do a thing? Where's the thing? And you can tell that the Commonwealth is that this is such a piddle shit objection that at the end of the day, the Commonwealth doesn't say, Judge, you were going to give a limiting instruction. Do that now. The Commonwealth just lets it roll. So, yeah. All right. So now let's go back here to the next sidebar. People are like, you've got to say sidebar. So Paul O'Keefe is on the stand. Do you recall where you and your family were for that sort of New Year's celebration? Yes. So I was with my wife and her family. Sorry, this is not Paul O'Keefe. This is somebody else. Okay. We went to Aruba the day after Christmas in celebration of my wife's mother's 70th birthday. I'm just going to say, when my wife's mother turned 70, I actually don't know how old she is. Ooh, that's bad. We're not going to Aruba. The cops make way more money than I do. So the court says, Mr. Lally, does it make sense that I give an instruction at this point? Let me see counsel at sidebar. So the court says, I don't know. The court reporter, I'm having trouble. Mr. Lally says, with regard to this witness, so they were in the room around the same time, but they did not see each other. The court says, okay, that's what I thought. So the next witness, there's conversation between her, meaning Mrs. O'Keefe, Mrs. Aaron O'Keefe, and the defendant in regard to what happened. With this witness, it may well be hearsay. The court says, so no instruction? Unless the court feels it appropriate for the 2021, which I'm fine with that, if that's what. And the court says, okay, I can do it in the final charge. So she works this all out with the, with Lally. And Yanetti's like, do I get to talk here? Just to confirm, if I may address the court, I'm just making sure. There was some indication on a report that Paul O'Keefe had told the police that he did not go over to Karen and John's place because they were fighting or something like that. That's what you're referring to in terms of when you say you're not seeking to elicit that from him? Correct. So he gets that information from his wife, not directly from your client. Mr. Yannetti says, okay. But no, I'm not seeking anything about. Mr. Yannetti says, then that's fine. Court says, so you don't want me to draw attention to it with an instruction? Mr. Lally says, correct. Okay, thank you. I'm actually going to give points to Lally here. I know people are like, we hate the Lally. And I get it, right? He is rival sports ball team or whatever. He is the villain of the. He's not really the villain. He's the I'm going to give him some points for basically he's actually being reasonable to a defense here. He's like, I'm not going to elicit this. Don't draw attention to me not eliciting it. And Yannetti has no issue with that because Lolly's actually being fair. Like I got no problems with what Lolly's doing here. Lolly is being all right. So Nella Brown says, "Oh my gosh, seeing you stream meet reminds me I need to mail out auction items. You and me both." But Nella, please do get on that because otherwise I will get the emails being angry. I've got a lot of apology things I got to send out because I still have some stuff from last year's auction I got to send out, but I got to get on that. So, yeah. All right. And then the court says, this is at the end of the day. This is day 7. The court says, could I see counsel at sidebar for a moment? So the court says, so do you expect Detective Lank tomorrow? I'm sorry. Do you expect Detective Lank tomorrow? No. The court says, okay, because whenever he testifies, I'd like a voir dire on the issue of prior allegations. So court says, just give us enough of a heads up. He says, I would say Friday at the earliest. Okay, who do you have tomorrow? Because it helps me prepare. Sure. So tomorrow I think we'll continue with Officer Saraf. Then we have Officer Mullaney. And then essentially it's going to be a number of firefighters. So we're going to have Timothy Nuttall, Anthony Flametti, Matthew Kelly, Francis Walsh, no relation to the other Walsh, Katie McLaughlin, probably, depending on how far we get with all of that. I'm not sure how much cross there is for these people, but I think it'd be Gregory Woodbury, then Daniel Whitley. And I'm not saying we'll get into all of these tomorrow, but these are basically, I'm going through the paramedics that dealt with Mr. O'Keefe, and then I'm going through the paramedics that dealt with Ms. Reed. Okay, Mr. Whitley and Mr. Becker would be the last two there. All right. Anything regarding any of that testimony that you expect limiting instructions on or any evidentiary issues we need to be concerned with? Yannetti says, I don't think so, Judge. Lolly says, I think even exhibit-wise, for the most part, it would just be run reports and a lot of the same photographs as far as where the body was when they arrived there and that kind of thing. Court says, all right. So anything that needs to be pre-marked will be marked tomorrow morning. He says, that's fantastic. 9 a.m. tomorrow, and we'll be here at 8:30. We'll start at 9 and be here at 8:30 if you want anything marked. Of course. We need one person from each side. Of course, I appreciate it. All right. Thank you, Your Honor. Thank you, Your Honor. So this is a lot of what happens. A lot of what ends up happening in court is like, there's a lot of like basic administration shit. And that's what that one's about. So that one is unspectacular. And I made a sort of decision to cover the unspectacular ones because they don't take too long, as well as the ones where I have some issues. But I think if I only cover like the stuff where I'm like, this makes me angry, then it gives an unfair view of what the trial was like. And I don't know. I mean, I feel like it's better for my views and numbers if I focus on like, let's be angry. But that's not really how I roll. You know, I roll with like, let's be fair and accurate, because angry is great. You know, angry makes more money. But at the end of the day, fair and accurate is what I want to be. So we're going to do it that way. And yeah, if you want all angry all the time, there's other channels for that. And I'm not going to call anybody out, but you know, so, all right. So day 8 we go to, whereupon there was a sidebar conference as follows. So the court says, so typically we play something only once. You played it twice and you're ready to play it a third. You need to ask permission to do anything like that. Okay. And so, this is Jackson, trying to play dash cam video, right? Court says, you can't just keep playing things twice. Okay. All right. Now here's the thing. Sometimes you need to, like, you have a witness and you are showing them a video and you show that video, Like the witness says something like, Bob threw the first punch. And you're like, Bob did not throw the first punch. It was actually Frank who threw the first punch, because I'm defending Bob in this scenario. And we got video, right? So I show the video, and it shows Frank throwing the first punch. So what I want to do in my defense strategy is I want to show that and be like, so where do you see Bob throwing the first punch? Like, we're going to roll this video. And the witness goes through it, and I'm like, okay, I didn't hear you say anything. Let's go back to the start. I want you to say stop when you see Bob throw the first punch. We're going to roll it again, right? Sometimes there's a method to this, right? Where you're trying to do things in a way that can, so it is really, this is kind of a level of micromanaging. And she doesn't apply the same rules to the Commonwealth, because there's several times when the Commonwealth rolls a video multiple times. So this is a place where I got to call some bullshit. So, yeah. All right. So they said, so you said we're going to keep focusing on the 26th or whatever it was. Are you planning on showing it for a second time? Mr. Jackson said, this one, it's hard to see the first time. I'll do my best to highlight what I'm asking him to look at. I may ask to play it twice, no more than twice. What is it? It shows Jennifer McCabe pass by an SUV and go to the house. Court says, can you freeze it as it goes on instead of showing it twice? And he says, I will. Once you show it more than once, it gets to argument, okay? I'll do my best. That's the other thing, is sometimes witnesses miss things, right? Did you see the thing? No, I didn't. Okay, can we show you again? Right? Can I show you again how, the moment that it is there? And they're like, yeah. Court says, so just once. Whereupon the sidebar conference is concluded. So the judge is like, no, you don't get to show things more than once. That's all. All right. Jumping ahead here. And we'll have a little look here. So we backed up a little bit from the sidebar. And they say, they're talking about Mr. O'Keefe's injuries. In your experience, let me ask another question. Did it look like he had, in addition to the egg on his right side of his head in the front, did he also have a black eye on the left side? If memory serves, correct, yes. So both eyes were blackened? Primarily the right side, if memory serves. Okay, and the laceration towards the right side? Yes. Over the right eye? Are those injuries that you've just described consistent or inconsistent with some sort of physical altercation? So Jackson is saying, doesn't it look like he was in a fight? Doesn't it look like he lost a fight? Mr. Lawley says, objection, Your Honor. Court says, sustained. Next question, please. Did it appear to you from your initial assessment, given your experience, training, and background, that those injuries looked like he'd been in a fight? Lawley says, objection. Court says, I'll see counsel at sidebar. And the court says, what is the objection? Lawley says, we don't know whether this witness has the basis of knowledge to document causality as it comes through the injuries that he observed. Court says, so if you can build a foundation, you can do that. And don't ask for demonstrations or having him repeat something. It's only one time. Judge Cannone gets into these ruts, right? She gets into these places where she gets stuck on something. And right now, what she's stuck on is one time only, Mr. Jackson. You don't get a do-over. And she's going to so yeah. Mr. Jackson says, I don't understand what the court's issue is. If people didn't pay attention to it, then the court says, are you pointing your finger at me? And Mr. Jackson says, no, I'm pointing my finger at the jurors. If the jurors do not see what he did, there's nothing argumentative about saying, what did you do? I want to make sure everybody saw what he did. Mr. Lawley says, I'm not sure. And the court says, they've seen it once. Mr. Jackson says, I don't know that they've seen it once. He's like, I want to make sure they saw it. Like, jurors see it. Right? So, court says, well, that's, and he says, as a matter of fact, they did see it once. Court says, I was watching. It was good enough, and it wasn't enough to respond to it with demonstrations. Mr. Jackson says, fair enough. Your Honor, just to dovetail off of what Mr. Lally indicated, this witness testified that for about the first 30 minutes of his testimony about his extensive medical background. I feel like it's a waste of time, but I could ask him a few more questions about whether or not he's seen many fights before or the product of that. And the court says, you can ask about causation as well. Like, the court's like, all right, we're not gonna, we're not gonna make you do that. So I think that sidebar is a defense win. Like, the defense wins that sidebar, and that's it, right? Lally had objections, and they don't go very far. That's the judge gives Jackson what he needs. You can actually see that he does a fair bit of massaging the judge when she's like, are you pointing your finger at me? And he's like, no, Judge. I'm not saying you suck. You do suck, but I'm not going to say you suck, at least not to your face. Instead, I'm going to say that maybe the jurors suck. We don't know if they... And Nella Brown says, what exactly is the problem with showing it twice? The only problem is that she's a bit of a, control freak. And I mean, here's the thing. I have ADHD. I'm often doing multiple things at once. And so one of the things I might be doing is I might be sitting there working away on some legal work, right? Doing legal work. And I might also, on the other monitor, have like a video playing, and it might be like I'm watching, EDB or Lawyer or somebody on the video. I might be, I might be watching a movie or like a TV show or something, just whatever, right? And, sometimes you're like, oh, I just missed something. And so I might go to the video and knock it back like 30 seconds because I was paying attention to the other thing and something happened and I want to go back to it. Like, this is not unfair. This is not unreasonable. So, yeah. All right. So, Jackson, once again, this is on day 9. He's asking people to focus their attention on the top of the dash cam video. And he says, can you pause it? And the court says, actually, I need to see counsel at sidebar. The court says, all right, there's one exhibit. It's a compilation. It's a man-made exhibit, right? Yes. Like, so I'm not sure I want to let in all of these man-made exhibits like this in. I understand that there are 600 exhibits and there's probably 100 exhibits of snow. If you don't like snow, Judge, you are sitting in the wrong fucking trial, because especially with trial 1 with Lally running it, oh my God, there was so much snow discussion. And like every witness was asked about the snow, and they were talking about how it's the world's worst snowstorm. And I'm sitting there going, you guys know this is nothing, right? You guys know this is, you guys know this is barely, yeah. Good to see you back, Runkle, awake at 4 a.m. Plus, it's my birthday. Happy birthday. Yeah, I mean, they're talking about like this is the worst snowstorm ever. And I'm like, ooh, honey. It's like 40 below outside here. Like it's and the snow is like, the snow's gonna get to be deep enough that like if you tried, the analogy that came to my mind is not a good analogy. The snow is going to be like waist deep by the end of the winter, right? And so when they're talking about like, oh, it's the world's worst snow, I'm like, is it though? Like you wusses, like. So yeah. Which would you rather be, a defense lawyer in Massachusetts or Sarah Boone's lawyer? Oh, that's rough. All right. So they say, I understand that there's 600 exhibits and there's probably 100 exhibits of snow. There are a lot of things I have not seen. So just because you all agree doesn't mean things are permitted as exhibits, okay? So you're asking him to focus on the top, but you're still pointing at the bottom. What is the purpose of doing this? Mr. Jackson says, once the bottom exhibit, which is synchronized with the top, once he makes his way to the stand, I'm going to ask him a couple of questions about the bottom and whether or not he recognizes the individuals only. And of course says, well, pointing at the top and asking him to focus on the top, Mr. Jackson says, and I'm asking him to focus on the top first. And then I will ask him to refocus on the bottom as the video continues to play. Court says, we will do this once. If we need to take a break and I need to see all of the man-made exhibits, if this were not favorable to the defense and the Commonwealth wanted to do it and you moved to keep it out, I would keep it out. So I just need to see it. It may break the rhythm. Do you plan to do more than this during the cross of this witness? Mr. Jackson says, no, I'm doing 1 3-minute video. That's it. Court says, I'm going to watch this and just be very careful about the commenting. And he says, sure. I would have loved to have seen these things earlier. Mr. Jackson says, we can make a habit of showing them. I have no problem with that. Ms. Little says, we provided them to the Commonwealth and they stipulated to them. So the Commonwealth's already seen them. The Commonwealth doesn't agree that there's any problems. Court says, I still need to let them into evidence. And this is evidence not typically done. So again, if it had been harmful to the defendants and the Commonwealth tried to do it, even if you agree as gatekeeper, I would keep it out. And Mr. Jackson says, understood. Okay, so go ahead and do it on this one, but we're going to need a break to see them before any other put-together compilation is put in. And he says, sure, understood. So she had great issue with this video, and the video was just like, the 2 dash cam videos, one over the other, right? So it was not exact, like when she's saying, oh, this is some man-made assembled thing. I'm like, barely. So, so then they conclude the sidebar. So whereupon the sidebar conference concluded. And then she starts another sidebar right away. It's like, all right. And then, so we've got a jury trial going on in the first session courtroom. Blank. So when something like this happens, it will be sort of an abrupt recess. So keep everybody, yes, they just open the door so people can go out. Okay. Court says, why don't I watch this? How long is this? 3 minutes? Why don't I watch this now? So, all right. And Mr. Jackson says, I was reminded, I'm happy to play the, and closer, please. You need to come close. I was reminded, I'm happy to play the 3 minutes. This has already been, not this particular video, but we have a synchronized video, I think, already with Good and Seraph's videos. Court reporter says, one at a time, counsel. Court says, and Ms. Little, I appreciate if Mr. Lally is questioning a witness, you can't object. She says, okay. You could certainly reach over and tell him to object, but you can't object. So the rule here that she's referencing is sort of, it's described as the like 1 horse, 1 rider rule. When you've got multiple lawyers, it's not that like everybody there can, can object. They gotta do this separately. So, okay. Just as this is Mr. Jackson's witness, I'd like to see this. Sure. We'll ask the witness to step out. So whereupon the witness exited the courtroom and the sidebar conference concluded. Why are they asking the witness to step out? Well, because they don't want to show the witness the exhibit in advance, right? So video is viewed. that is the extent of approximately the extent of the length of the video, the clip that I was going to play. Of course, it's okay. 10-minute recess. All right. So that is where they are there. And then they have another sidebar immediately after. Like, they don't get to do anything. It's just another sidebar. This is sidebars from trial 1. And you could tell it's sidebars from trial 1 because Lally talks in these, transcripts. Like, Lally is allowed to exist, which is how you know it's trial 1. So court says, all right. So I noticed that it said 6 minutes and something up there. The two of them. The witness testified to a 1-minute conversation. You're going to show a 3-minute snippet. So you have pre-marked exhibits. That doesn't mean they're in evidence. Apologies. So you still have to introduce those into evidence. So you have to lay a foundation. Before you can say, I'm going to show you this and where in this did this conversation take place, he has to acknowledge that it did take place in there. And if it doesn't, it's not coming in. Mr. Jackson says, okay, I'll lay a foundation. Of course, it's okay. So you need to, but there was a confusion about you pre-marked 600 exhibits. That doesn't mean they're in. So far, there may be 15 exhibits in evidence. And Mr. Lally says, Your Honor, may I talk with Mr. And she says, you can go ahead and talk. Let's save the time. What do you want to say? And she's like, and Lally's like, I wanted to talk to him not at sidebar. I wanted to talk to him privately. And she's like, no, talk now. Lally says, no, I just wanted him to relate something to the court. With regard to Saraf, that is in evidence. With regard to Good, that video will be in evidence, but it's not now. I understand. And it won't be until I let it in. Do you understand that? And Mr. Lally says, I completely understand that. My request to Mr. Jackson would be that it be admitted de bene, given that we fully expect it will be admitted, goodwill. And the court says, we're not going to do that with 600 exhibits. Mr. Lally says, no. But for ease of doing this today, they may both be in. But if this witness doesn't acknowledge that it occurred anyway on that before you ask him compound questions, it's not really clear what his answer is. You need to lay the foundation to get it in now. Right. So, Firefighter Flametti, I want to draw your attention to the top video. I may pause it and ask you a couple of questions. So, whereupon the video is played. All right. So they go through a bunch of these, and yeah. Also, I want to give a little bit of a shout out to Hedgehog in Space, who was very helpful with annotation. So thank you, Hedgehog. I don't know if I'd be able to do this right now without Hedgehog's help. So I was going through and reading all of these, but Hedgehog was very helpful. Sent me a breakdown with like page numbers and all of that. And so I really do appreciate it. It's really, it's just tremendous, tremendously awesome. So, all right. Okay. So, they're saying, I want to direct your attention to this person that appears to be a firefighter in the middle. Do you see that person? Yes. Who is that? Mr. Lally says, objection, maybe approach. So now they have a sidebar that is not initiated by the judge. So court says, the objection is sustained. I'll see counsel at sidebar. And the court says, what do you want to say, Mr. Lally? Your Honor, so what I think counsel could do is counsel can direct the witness's attention to a particular part of a video or a particular point on the screen and ask them if they know where that is or if they recognize what that is. But describing it to him and then asking him to confirm it, I think, is improper. So the testimony has to come from the witness, not from counsel. And I like Jackson's response here. He says, that's completely untrue. This is cross-examination. So I'm allowed to lead the witness. The court says, you can lead the witness, but not on something he's not adopting at all. You cannot narrate this video, and that's what you're doing. And he says, I'm leading this witness, asking him, does that appear to be you? Does that appear to be somebody else? And I'll leave that with the answer that there is. And the court says, And then you said that this is a firefighter. It's a yellow jacket. So Commonwealth versus Pleas is an important case on these issues. You've got a video up. The video speaks for itself. A lot of what you're doing is improper. I think Lally's objection here, I think his objection to this is basically to break up the flow, to mess with Jackson. Sometimes you object to mess with the other side. You don't really care about the objection, but you kind of want to break up what they're doing, see if they're able to recover, that kind of thing. Because at the end of the day, who gives a shit that he called him a firefighter? Right? Everybody already knows this guy's a firefighter. So who gives a shit? This is a messing with the other side objection. He says, Your Honor, the court says, excuse me, but there's only been one objection, and I'm sustaining that objection. You can go back and do it properly. Okay. So it got sustained. Fair enough, right? And that's the thing, is if you're making sniping objections where you're trying to break the other side's momentum, you want to make sure they're good objections, right? You don't want to make a sniping objection where you are breaking up their thing and the judge is like, yeah, your objection is bullshit and counsel, stop it. Because counsel will yell at, or the judge will yell at you if you make bad objections for the purpose of breaking up somebody's, because if they're doing it right, you don't get to mess with them. You only get to mess with them if they're actually screwing up. So, all right. So they finish with firefighter Kelly, and then they hand it off to Yannetti for cross-examination. And before that, he says, may we approach? So they have a sidebar. And he says, Your Honor, I just wanted to flag for the court and to minimize the interruptions here towards the end of my cross-examination, which I don't think will be very lengthy. Anyway, but I intend to refer to a video which I'm not sure is in evidence. It's the widescreen video of the Seraph video, which has been pre-marked, and I'd like to offer it into evidence, given that I believe the foundation was already laid through Officer Seraph. Court says okay. And then have the witness refer to it. I'm playing a 15-second portion of that video, and that's it. Court says okay. Any objection? Lally says no. Court says okay. I actually, once again, think Lally is being reasonable there. Because he's like, I just want to get the stage set up. This, I think it's in. Lally doesn't have a good reason to keep it out. And he's like, no, we're good. I mean, Lally was boring, but he didn't feel dirty most of the time. All right. So here we go. All right. So they've got a thing there. Will you agree with me, sir, that we heard what you heard that night, which is he's dead. He's fucking dead. It was kind of hard for me to hear. I heard about, does he do drugs? I couldn't really hear the background. Yannetti says, if I may have a moment, Your Honor. So sidebar. He says, I don't want to overstep my bounds, but I'd like to play the video one more time just for the purpose of directing him more towards the beginning of the video, which it is before the statements that he said. And my argument, and the court says, for what purpose? And he says, just to see if he can. I heard it. I think other people heard it. But doesn't what matter is whether the jury hears it? And he says, correct. So that's the law, correct, Mr. Yannetti? Oh, for sure. But the testimony right now, if I can get the witness to acknowledge it, I think that will assist the jury. And I don't necessarily think there is. I'm not looking to unnecessarily delay the trial. I'm just looking for about 10 seconds. The court says, no. Play it again and just ask him if he heard that. So the court says no, but then tells him to do exactly what he was asking to do. Right? That's it. So thank you. Don't ask him whether he heard. Just say, what did you hear? Good. Thank you. So whereupon the sidebar conference concluded. He's like, I want to play it again. The judge is like, no, play it again. He's like, okay. The trials of a defense lawyer. Savory Runkle defending unsavory characters. That's kind of the nature of the game. So, yeah. All right. Then we have another sidebar here. They ask, do you recall which foot the sneaker was on? I don't. Because I see counsel for a second, and they go, this is for scheduling purposes again, because we've moved courtrooms, and it's hard to get, with the other trial going, our jury going. So I wanted to give them enough time to do this. How much longer do we have? We're breaking for the day, but how much longer do you have with this witness? Lally says, not much more. Okay, and are you doing the cross for this witness tomorrow? Yes, Your Honor. How long do you think your cross is? So this is a funny error. The juror. This is not the juror talking. This is Jackson. They put Jackson down as the juror. It's not extensive. I would say 20 to 30. 20. If the juror spoke up to talk about the cross-examination, this would be a major problem. But the court says, okay, because I'd rather finish the witness before we do the view rather than interrupt this testimony to go do the view. So I need to coordinate the bus. Yes, I think I can do it in 20 minutes. Mr. Unetti, so we can get going around 10, 10:30 at the latest? All right, 10:30. And I think it's about a 2-hour view. Mr. Lally says, I don't even think it's that long. Court says, I have mundane things to worry about, ordering lunch and things like that. Court says, no, I understand. But I mean, for me, no. I mean, from Dedham to Canton on scene, probably 10 minutes the most, 15 minutes. I mean, I don't know why. Court says, then why is it going to be 2 hours? Mr. Lally says, I'm sorry. Then why is it going to be 2 hours? And he's like, I just said it probably wouldn't. Lolly's like, I just said we could do it in less than 2 hours. Why are you yelling at me for this? Mr. Lally says, I didn't know it was. Court says, I was told it's a 2-hour view. No. Mr. Jackson says, that's not from us. Mr. Unetti says, that would be max. I think it's going to be shorter than that. Mr. Lally says, 10 minutes might be a little, I mean, because the vehicle will be there as well, which we need to address. But I think we could probably do max an hour, hour and a half, like on the bus there and back. I think we should be able to do that. Court says, yes. Mr. Jackson says, I agree. This is like basic scheduling stuff, but it is funny to see Lolly getting, he's like, I didn't say we needed 2 hours. I said we could do it in less. Why are you giving me grief? So it'd be Ms. McLaughlin, Lieutenant Woodbury, firefighter Daniel Whitley, another firefighter, Jason Becker, then probably some combination of Lieutenant Gallagher, Sergeant Good, and Sergeant Lank. Okay, depending on how far we get. 2 or 3 minute view openings, right? No longer than that? Oh, no. If that. We can discuss it later. Are they all set to go now? Yes. Okay. I love that Lolly's like, we're going to be real fast. And she's like, why? All right. So they wrap things up. And then they have another sidebar. Mr. Unetti says, just briefly, Judge. I just thought it would be helpful to get some guidance from the court in terms of what you expect with regard to the view. There'd be a brief view opening in the courtroom, a couple of minutes each. Yes. When we get to the site, do you allow counsel to, direct the jurors to look, point out how much input can counsel have on the view? Court says, you can draw their attention to something. You can't tell them why you're drawing their attention. He says, oh, of course not. The distinction she's making there is a reasonable distinction. She's saying you can say, I want you to look at like the back end of the car. What you can't say is, I want you to look at the back end of the Lexus because it will show that, Karen Reed is a murderer. Duh, duh, duh. Right? That's argument. So that's the distinction. I don't know actually anything about Camelot's legal stuff. I hadn't heard that he had legal stuff going on, so I guess I'll have to look into that. So the court says, but you can draw their attention. Mr. Unetti says, typically we start with the prosecutor. I ask you to look at whatever. And then we'll ask you if you typically, the prosecutor asks the defense counsel, do you want to add anything? Okay, so we can go back and forth with regard to whatever you want to point out, or okay, that's all. And then if there are additional things you want, then you can point them out. Mr. Lally says, and then he can comment? Yes. Okay, that makes sense. While we're talking about this, too, the oath indicates one on each side. So just let me know who's going to be the one talking. Mr. Unetti says, okay. Mr. Jackson says, is the jury relegated to off the property, or are we going to be able to go on the property like the property line? Court says, I did not arrange this, and I asked you all to talk about it. She's like, I don't know. This is your fucking fault. So, yeah. You sort this out. You're supposed to be telling me. And I see, hello, everyone from Denmark. First time I caught alive. Some of the people on our cruise were from Denmark, which was cool. So, yeah. Yes, just the public road. There's no private access. And the court says, I think that's what the motion said. Okay, that's fine. Thank you, Your Honor. So whoever is talking, I don't care who talks at this point, but please speak into the microphone. Mr. Lally says, there's a couple of things I wanted to address. Number one, with respect to the view, I'd asked before, and I just need clarification so the state police know where to put the vehicle. So my preference would be in the area of the fire hydrant, the flagpole, and all that. The court says, is there an objection to that? Whoever speaks has to come in. Mr. Jackson says, there's no particular objection to that. I mean, I guess it depends on where it is. But no, the area of the flagpole, the fire hydrant. Mr. Unetti says, the only thing I'd be concerned about is I think we're going to be standing by the area by the flagpole on the street and pointing out things. The car might be in the way if it's parked right there. I'd ask it to be parked backed up closer to the driveway if possible. You can face it towards the flagpole if you'd like. Court says, okay. Lally says, okay. There's a couple of car lengths. And Jackson says, and all that is consistent with the testimony as well. Court says, so you have a million pictures of this. Why don't you all pick a picture, put an X on it, and tell the state police to drop it there? She's like, give the police a map, right? Give the police a map, please. And so that makes sense. I'm fine. Two other things just briefly I wanted to flag for the court and for counsel. So one of our witnesses is Ms. Terry Kuhn. She's with the veterinary lab at UC Davis. Okay. There's an issue which I can get to if you want, but I'd prefer not to. She has a child that, and the court says, so she has a personal issue. So you don't need to get into it for these purposes. Good on Judge Bev. And you're not going to hear me say this a lot. You're not going to hear me say, good for Judge Cannone a lot on this one. But good for her. And the reason why I'm saying that is because she had to know that these transcripts would be getting released eventually, or could be getting released eventually. And so when the, when Lally starts talking about her child, absolutely, Judge Cannone was right to go, shut the fuck up, Lally. Just shut up. Stop talking. It's a personal issue. That's all you need to say. Don't put her child in the transcript. You suck, Lally. So, yeah. So, has a personal issue. She needs to testify at a certain time period, and it may be significantly out of turn for where I normally would have had her come in. So what I would like to do is essentially fly her in on May 14th, have her testify on May 15th, and be done on May 15th. May 15th should be a full day, so that's my intention to get her done. And Mr. Unetti says, we will certainly accommodate witnesses' schedules. We appreciate the fact that you're giving us a heads up in advance about when people are testifying, and we'll do the same for you. This is how lawyering should be, right? This is how lawyering should go, where they've got this issue and they're working it out, and they're being reasonable about it. They're being decent to each other. I think it's easy to forget that this is like how things should look because we saw so much of Brennan being such a shit. But I mean, this is actually really nice, right? This is decent, right? And yeah, so yeah. Hey, stranger, good to see you. Good to see you. Um, and they're accommodating the witness. They're not being dicks about it. I love to see it. So sure, the court. All right, May 15th will be your testimony, regardless of where we are. Mr. Lawley says that'd be my request. Yes. Okay, and there's no objection. No objection. All right. Is there something? Mr. Lawley says one last thing, Your Honor, because I had representatives from media approach me about it, indicating with regards to the children and videotaping their testimony. Their indication was that they would abide by whatever the court orders. Court says okay. They indicated there was nothing in the written order regarding that. So my request would be if the court could supplement or put something in writing in reference to that. Court says, okay, you're putting on live witnesses and perhaps reference the sane interviews when they were even younger? Correct, yes. All right, so what is the Commonwealth asking me? They cannot film the children? Mr. Lawley says, basically, that's what I'm asking, is that there be some sort of supplemental to the court's order regarding. Court says, I planned on doing it. I just didn't know. No, I'm bringing it up right now because I'd rather deal with it now rather than later. Court says, do they have the ability to do voice altering? I've seen that. Are you asking me to do that, or are they okay with their voices being? Mr. Lawley says, what I would ask is that there be no recording whatsoever other than the court's recording, obviously. And Mr. Yannetti says, no objection. Keep in mind, the court recording in general was something that favored the defense, right? The defense was happier to have like this broadcast than the Commonwealth was. But Yannetti's like, we don't need to broadcast the kids. Also solid, right? Also a good a good move. So I approve of all of this, right? So far, we've seen a lot of Lally and Yannetti and Jackson and Ms. Little and Ms. McLaughlin all being decent humans. And, that is good. So court says, okay, I'll issue an order. Thank you. Court says, I need also all the compilation videos, these things that you've altered by putting it together or enhancing in any way what you've done with them. I need all of them, okay? Court says, because our witnesses are surprised, but I have to make decisions on whether these are coming in. So if you can get me a copy of everything, you've got your expert here. If you can get a copy of everything over for me by tomorrow so I can review it over the weekend and some guidance on what you suggest is admissible for or what you intend to do with it. Okay. Anything else? Not from the Commonwealth. Okay, we'll see you tomorrow. Lots of days are going to end with sidebars like that because, that's just how that goes. Now, we hit a goal, although technically it says we missed the goal. We didn't miss the goal. Somebody got it in 2 seconds after the goal closed. So we're counting that. So somebody asked what my favorite animal was to see. And it's going to be this. Whoop. Why is that not up? All right. I got to show the right one. It's just now some of you are saying seal. And everybody who said seal, you are wrong, because that is not a seal. That is a sea lion. And there's 2 important differences between seals and sea lions. The first difference is that sea lions are much bigger. And That one is a baby sea lion. Let me see if I've got a picture of or a video, something of a big sea lion, because they get pretty giant. Is this a big sea lion? Here we go. Yeah, this is a much bigger sea lion. It's not a great video, but it's a big sea lion. So two differences. Sea lions have external ears. So they got little ears that's, you can see the ears on this one, right? And so that's one difference with the sea lions. The second difference is that sea lions are so much bigger than seals. And when I say so much bigger, I mean that they are, that they get like, to like 800 pounds, whereas a seal gets to like, 100 pounds. So, sea lions are great big monsters. Now, the sea lions were super, super chill. They were just hanging out. They did not mind that we were walking by them. They did not mind anything. They were just like all chill, all whatever. And in some places, I'm used to like Vancouver area, like the BC West Coast. And the sea lions there can be super aggressive. They can be super mean. These ones were very chill. And I got to say, like, just swimming around, I had sea lions pass me. At one point, it passed me so close that I felt the sea lion brush my arm, which, they're a great big massive monster swimmer. And I also had a moment, and I don't have the video yet. I'm going to try to get the video for you for another day. I was swimming, snorkeling at one point, and this sea lion comes swimming along, and we almost bumped into each other. We almost crashed into each other face to face. And I was a little shocked because I was like, I do not want to run into a sea lion. That thing could me up. So, yeah, they were very, very awesome critters. And yeah, I love them to bits. Also, hello, Megan Fox and Broken Baker viewers. Welcome aboard. Glad to see you. So, yeah. Good to see you, Runkle. I haven't seen you since Amber Heard and Dear Johnny. Well, I keep doing keep doing streams, so you can check me out. So, yeah, sea lions are great big things. They're big monster critters, but they're super. And let me show you a picture. I'm going to show you a picture of one of the sea lions, because they are such. They're like super lazy in the cutest ways. And let's see. Where's that picture? Here it is. Yep. There we go. They just find all sorts of places to just like hang out and just have a little nap and a little and they're just sunning and whatever else. They're just like, I was just like, oh man, I feel you, sea lion. I just want to have a nap too. So I get it. They were great big sweethearts, and I love them to bits. And yeah, so when you ask what my favorite animal was to see, that was my favorite animal. And it was not it was not even close. So yeah. All right. Let's go now to here we go. All right. So now we got another sidebar, and yeah. What is it? There were some other really awesome things that I saw. I saw penguins. I didn't get good pictures of the penguins, but I saw penguins. And I was swimming, like snorkeling, and I got to see penguins super up close. Like I got to see penguins, and they were just what do you call it? They were just like out there fishing. It was so cool, especially because you get to see them out there fishing, and so there's like tons of fish, right? There's just so many fish. And as the penguins are swimming along through the fish, they like the fish part around them. So there's like this bubble of no fish as the penguin is trying to swim to catch the fish. Where was I? I was in the Galapagos. It was amazing. And yeah. And somebody else was saying, did I see turtles and tortoises? Yes, I did. So with that in mind, let's set another goal. I got some turtle video. I got some tortoise video. Those are different things, by the way, the turtles and the tortoises. But yeah. So, all right. So, next sidebar here, and this is day 10. So, they go, so while you bring your witness in, Mr. Lally, I'd like to see counsel at sidebar for a brief moment. If they could bring in Ms. McLaughlin, please. And so, good morning. Please, or come closer to the microphones, please. So, a few things. I was given copies, I think, of Exhibits 26 and 379 from the defense this morning. Do those contain all the videos that you intend to introduce as evidence? Ms. Little says, I provided the court with copies of the ones that we'd put side by side. Okay, I want all the ones you intend to introduce. I don't want surprises like this. So I know you can't get them today. I thought it was clear. I wanted to spend the time this weekend reviewing them. Ms. Little says, you want all our exhibits for the rest of trial? She says, the video ones, the ones you intend of the side by side. Whatever you're playing for the jury, not the print ones. I'm not concerned about the print ones. Mr. Jackson said, anything that's video, anything that's video. I believe the Commonwealth already admitted the rest of the just regular dash cam videos. The court's like, I don't care if he admitted it. I don't care. I believe the Commonwealth already admitted the rest of the just regular dash cam videos. Court says, so nothing really is in evidence, and that's part of what I'll talk about here for a minute as well. Mr. Lally, I would like at least the corresponding Commonwealth dash cam videos that the Commonwealth has the original dash cam videos that the Commonwealth has introduced. That's one. Second thing is yesterday, Mr. Jackson, you referred to the court reporter as Nancy. Duh, duh, duh. We are much more formal than that here generally. But my big concern is that I've known Madam Court Reporter for 35 years. I've never called her by name, particularly in a case where people's personal information has been put about on the internet. I cannot allow that, all right? I don't think you meant anything by it. Mr. Jackson says, I certainly didn't. Court says, I'm not saying that you did. We have to be extra careful about that. By the way, she's like, do not call the court reporter Nancy. Fuck you, Jackson. No Nancy. How long do you think it takes for Judge Cannone to refer to the court reporter as Nancy? Because she does in this trial. She does. It's so fucking dumb. It's so dumb. She's like, oh, yeah. Hello. I don't get it, right? And the thing is, you know, I refer to a court reporter however they want to be referred to. No defense lawyer wants to pick a fight with the court reporter, right? Nobody ever wants, because you don't want to do it. So did I hear MCR was on anti-dab? MCR? Oh, Madam Court Reporter. Okay. I did not hear that. So yeah. Yeah, I this is such a stupid thing to, yeah. The third thing is, please come to sidebar before any videos are played that I haven't seen yet, okay? Mr. Lally says, sure. He says, what's been going on with the exhibits? I know you pre-marked a ton of exhibits, and I know Madam Court Reporter has been here all day marking exhibits, close to 600. It's too sloppy. We're going back to the old-fashioned way. Yesterday, the exhibits are available for the press on Tuesday and Thursday afternoons. That wonderful person from the clerk's office here that is doing that had the good sense to send it to me beforehand. And exhibit number 140, the fire department report, when I reviewed it, I don't see these exhibits. Ordinarily, when exhibits are introduced into evidence, I get to see it. I have a copy of it. They're supposed to be held by the clerk and held overnight. I don't know where these exhibits are. And if there are 600 of them, they all need to be here. So we're going back to the old-fashioned way, because on page 1 of 5 of what's been marked as Exhibit 160, we're going to mark this as for identification for these purposes. Court reporter says, that will be G for identification, Your Honor. Whereupon incident report, previously Exhibit number 160, was entered and marked as Exhibit G for identification. On page 1 of 5 is all of John O'Keefe's personal identifying information. That could have been on the front page of the Globe today. You really think the Globe is going to do that? Ms. Little says, it's not our exhibit. Like, this is not our fault. This is the Commonwealth. Court says, it's got to be redacted. All exhibits have to be redacted before they are admitted into evidence. It may take a half day. We'll break early if you need to do that. But they have to be cleared. In a case that doesn't have press interest, we let people do it maybe later that day or the next day. It has to be cleared. This should never have happened, Mr. Lally. Mr. Lally says, yes. The court says, so it's not going to happen, all right? So pre-marking exhibits is out. We're going to do it the old-fashioned way. If you're in agreement with exhibits, I still need to see them beforehand before they come in. Sure. You don't need to go and authenticate everything if you're in agreement and it's obvious. Got it. And I don't need 100 pictures of snow. I feel you, Judge Cannone. I feel you when she's like, I don't need 100 pictures of snow. I'm like, me too, Judge. Me too. The jurors aren't going to look at 600 exhibits. I can't imagine that they won't. All right, so let's just move this case along. I'm not interfering with how you try the case, but I do have a role here, and these are important, all right? It was supposed to be gone. I was glad I was still here. This could have just gone out, okay? Mr. Jackson says, please apologize to Madam Court Reporter. I certainly did not mean to offend. Court says, nobody thinks you meant it. And I think it just underscores the point that the less unnecessary chatter, even during questions, the better. Right. There's less of a chance of this. Just ask a question and no comment. Even the CPR. You're not being certified except as we're not used to that here. Right. And I really don't want it. Right. And there's less chance of a problem. Okay. You ever been in this point where you're being like yelled at by a boss or something and you're just like, okay. I get it. That's clear that's where he is. All right. Thank you. Okay. We'll bring the witnesses in. Wow. Wow. Yeah. That was something, right? All right. And so they have another sidebar here. And court says, hold on, I'll see you at sidebar. Whereupon there's a sidebar conference as follows. By the way, she's like, you should not be, you need to not piss Madam Court Reporter off by, calling her Nancy. And then she's like, oh, you know how Nancy spent all of this time pre-marking the exhibits? Yeah, fuck that. Throw that all out. We're starting over. Who do you think Madam Court Reporter liked better in that moment? Mr. Jackson, who referred to her by first name, or Judge Cannone, who just like made her redo 600 fucking exhibits? I'm guessing that it wasn't it wasn't Jackson who was the on who was shit listed, right? So yeah. All right. And then you told Trooper Proctor as read. Karen then turned to her friends and stated, "Hold on, I'll see you at sidebar." How long is the statement? Does she need it right in front of her? Mr. Jackson says, "No, it's one sentence, Your Honor." Okay, go ahead. Thank you. The judge is like, "How long is this statement?" He's like, "I'd be finished by now if you hadn't interrupted me." This, I mean, it's funny because it's not happening to me, but yeah. So another sidebar. Objection. What is it? So they ask, "Who is her dad?" And he says, "Objection." The witness says, "I don't know." The court says, "The objection is sustained by," and he says, "Do you know who her family is?" Mr. Lally says, "Objection. Sustained. May we approach, Your Honor?" Yes. What is the objection? Relevance. Why the fuck was it sustained when she's like, "What is the objection?" Because if you are sustaining the objection, shouldn't you know what the... Okay. How do you respond to that? Mr. Jackson says, "This witness has a deep friendship with Caitlin Albert. She knows the Albert family. We have photographs of her traveling with Caitlin Albert, going to the beach with Caitlin Albert, going..." How old are these photographs? I'd say probably they're adults. She's only mid-20s or so. I won't ask her age, but they can't be more than a couple of years old, 2 or 3 years old, I'd guess. They have social media accounts with their friends. They tag each other. They vacation together. They drink together. They socialize together. She's diminishing the relationship between Caitlin Albert and her knowledge of the Albert family. I think she knows the Albert family. I think she knows the Albert family, and she knew where the import of 34 Fairview Road. I don't believe it's the first time she's been to 34 Fairview. So you can focus on that. The other is too extreme. It's not relevant and certainly not probative. It's absolutely probative. It's absolutely... She just said, "I don't know the Albert family." Once she says, "I don't know the Albert family very well," it's absolutely probative to be like, did you just lie to this court? Did you just bullshit us? So we are talking about the Karen Reed first trial sidebars. Like, did you just bullshit the court is absolutely a credibility issue. Mr. Jackson says that she knows the family, or the court says the house. You say it's relevant to the house, her being at the house, and she knows the family and she's been to the house. You can do that. Social media, traveling together. Is Caitlin Albert going to testify? Mr. Lally says yes. She was just one of the people at the house that night. Mr. Lally says correct. She was also at the Waterfall Bar that night. Court says yes. It's not probative. If any relevance, there's a little bit of a stretch too. But I'll let you get into that. She knows her and she's been to that home before. Like, what's the distinction here? Mr. Jackson says, "Just so we don't have to approach sidebar again, I've got photographs of them together. May I mark those?" Court says, "You can mark them for identification." "And show them to her?" Court says, "No." Court says, "Mr. Lally, for the record, I've never seen any of this. I don't even know what counsel's talking about as far as photographs and social media." Mr. Jackson says, "But because it's impeachment." And the court says, "But if you knew you were going to use it, you have an obligation." Mr. Jackson says, "I didn't know." She says, "Hold on." Whereupon there was a pause in the sidebar conference. I love the whereupon every time there's a detail there. Jurors, we're going to send you out. Mr. Court Officer, 10 minutes. And court says, "Show them the photographs and we'll have a short voir dire. We'll come back out in 5 minutes." It is bizarre to me that defense counsel has to show their impeachment material to the Commonwealth ahead of time. Right? Like, you have to warn the Commonwealth what their witnesses might lie about. Like, are you kidding me? Yeah. All right. Anyway, so Ms. McLaughlin, I'm going to step out for a minute. Show them what you've got and let a court officer know when you're ready. So, all right. So, Mr. Jackson, let's mark for identification the items you told us about at sidebar. Mr. Jackson says, the first one would be, do you want me to describe them for the record, Your Honor? No. So they're not to be put up on the screen. These are 4 items. One of them, don't describe them. I need to see them. So let's bring them up and mark them for identification, Madam Clerk. Then we'll give them back. But I need these marked for identification and I need to see them, so I'll mark them first. So they marked them as H through K. All right, so we have 4 pieces of paper marked for identification that appear. You got these off social media sites, Mr. Jackson? That's correct. Okay, when did you get these? I couldn't tell you the exact date, but we've roughly had them between 6 months and a year. Court says, okay, Commonwealth, you've not seen these before? No, Your Honor. Court says, all right, so we'll talk about Rule 14 in a little bit, but we'll bring the witness in. You can ask her questions, Mr. Jackson, about her vacation that you mentioned, the drinking that you talked about, the relationship with Ms. Albert. I've forgotten her first name already, Caitlin, and about the house. So you can ask her questions about that. You can show her these exhibits or these marked for identification if you need to. You may have trouble actually getting those into evidence, but I'm going to let you find out. You can ask her to identify them, how long ago they were, and things like that. Thank you. Could we bring in Ms. McLaughlin, please? And he says, may I approach? Yes. And Commonwealth, you just saw these today? Yes, I did. And you objected at sidebar that these come in? Correct. So, yeah, this is a little bit bizarre to me. But yeah. Okay. Skipping ahead. Zoom, zoom, zoom. If you're like, I can't read that fast, that's fine. We're not supposed to. All right. So here we go. So they have you didn't quite get everything in that you mentioned at sidebar, so that's not coming in. I just want to make sure I stay within the parameters. So the court says, so you said they'd been out drinking together and all that. One person was holding a beer at a beach in a cropped out photo. She's not in a bar room or anything. Mr. Jackson said, no, I didn't suggest they were in a bar room. That's what I was referring to, that they, I'm assuming that if Caitlin was drinking, she was drinking too. Court says, you didn't get it from them, so you can't do that. He says, I'd forgotten to, and I should do it here at sidebar. I'd forgotten to actually refer to the third photograph. Is it J, K? He says, no, J. May I have those, please, those photographs? I think it's this one, that one. I forgot to mark it or mention that this was K, that it's been marked. Court says, okay, they look like young girls in bathing suits. Mr. Jackson says, I do want to make a record that I disagree with the Commonwealth in terms of the Rule 14 objection. The rule that we disagree, this is pure impeachment, as the court well knows. This is not something that we're going to use in the case in chief. Indeed, I was never, and I can show the Commonwealth and I can show the court, my order of proof in terms of my outline, I literally do not bring up these photos unless ... she denied the relationship or she was trying to distance herself from the relationship. So, they're saying we don't have to tell them all of the things we can catch them on if they lie, because if we tell them all the things that we can catch them on if they lie, then, they're going to tailor their testimony to exactly what we can catch them on and what we can't, right? Where was your puppies? The puppies were in puppy jail, and they love puppy jail, so, but they were happy to see us back. So they say, I think that's obviously some level of deceit on her part. She knew there was a relationship. I can prove there was a relationship with these photos. The level of relationship is up to the jurors to decide. But she said her first answer, Your Honor, was I said, who is Caitlin Albert? And I just left it open for her to say. She's a friend of mine. She's an acquaintance. We went to high school together and I've known her for 10 years. And she said none of that. What she said is there was a girl in high school with that name. And that's a lie. And that is why we're here. And now she's changing that story because I'm about to impeach her with those photographs. I don't think that's a violation of Rule 14. This is pure impeachment. Of course, says Mr. Lally. What I'd say is I don't think that is a lie. I think that's exactly what was borne under testimony in voir dire. The last thing I would say, just a flag for this court, is this is a witness who's been harassed by Mr. Carney. Turtle Boy has entered the chat. Turtle Boy. Yeah, Zora got more than she should because Zora seems to get fat real easily the instant she's not on her specified food rations because she has fattened, and so she's a little extra snuggly now. And she's not going to like that we're going to be like, yeah, you can't have as much food as you've been having. So, yeah. On this specific Mr. Carney on the specific issue. So if we're going down this road as far as impeachment is concerned, I intend to get into that. The court says, come to sidebar before you do. So I find that it is a violation of Rule 14. So these photographs won't come in. We'll keep them handy in case you need to refresh your recollection. They are not to be shown on the screen. Understood. I expect that the press will not see these photographs. No, of course not. Of course not? They've seen all sorts of things. I was told this morning that one of these photographs has already been circulating today. Not from us. Not from us. I'm just saying that when you said, of course not, I have to be concerned about these things. I understand. I just don't want the court to cast aspersion on us that we were out there leaking stuff. We were not. Court says, no, I'm not saying that. Yes, you fucking were. Yes, you were. Courts, Mr. Jackson says, we don't play those games. Am I allowed to refer to the photo, just not show them? In other words, what is this a photo of? Does it appear to you to be a photo taken with Caitlin? No, you could talk to her about her relationship. I think she will tell you that she was at a beach. Mr. Jackson says, okay, you can talk, and if she doesn't, you can show her. Okay, I just want to make sure I'm clear. I don't want to overstep. Can I ask if you ever been photographed socializing with anyone? Sure. Okay, I think I'll get to the answer, and then I won't have to show it. Okay, all right. So Jackson does a very good job of tiptoeing around. Like, she's like, here is the fence. And he's like, can I lean over the fence? And the judge is like, okay, you can lean over the fence. And he's like, can I put my arm over the fence? And the judge is like, okay, you can put your arm over the fence. And he's like, can I lean real far over the fence? And she's like, okay, you can lean over the fence. And he's like, can I move my foot over the fence? And she's like, yes, but you can't put both feet over the fence. And he's like, okay, cool. Jackson did a really good job. This is part of why Jackson is good. He did a really good job of like finessing her no into a sort of, right? And I give serious points for that. Also, Tiffany, just because, thank you so much. It's really appreciated. So thank you. And a good doggy jail would follow your feeding instructions. I know, but we have yet to find one that actually follows them strictly. The other thing is Zora is kind of a bitch, and I mean she is literally, but so what Zora will do is Zora will sneak food. She is not like food territorial or anything like that. She doesn't bark at other dogs who get near her food or whatever else. But when Potter's eating, if Potter knocks a kibble outside the bowl, Zora's like, that's mine. And so, and if Potter is like, we got to watch Potter, because if he's not feeling all like, if he's having a not so hungry day and he doesn't finish, Zora's like, I'm going to eat that then. So what I suspect happens when Zora goes off to the kennel is that like Potter or other dogs don't finish, and Zora's like, I'll have that. And so I suspect that they're giving her like the 2 cups of food that she's supposed to get. and that she is stealing extra kibble and getting away with it. Because we make sure she doesn't steal extra kibble, and Zora really tries hard. So I think that's what's going on. And somebody who's saying, I feel like that hits the goal. I think that you're right. So let me show you another video here. I'm going to find a video here to show you. Let me see. I'm trying to think of, I'm looking at these videos, trying to figure out which one is actually the video I want to show you guys. I think it's this one. Oh yeah. So this, and I know it's not the best view. Those are sea turtles. Multiple sea turtles. And you might be asking, what are multiple sea turtles doing? On top of each other. Yeah, that's is there I don't know if there's a good yeah, I don't know if that's sufficiently romantic. This is sea turtle mating season. And so the sea turtles are getting it on, which they do in the water. And so the other thing is that sea turtles are not good at coordinating the mating. And what I mean by that is that apparently, and this is like according to the tour guides, the sea turtles, they will do a thing where there's like one female and like several males will show up. And the thing is the way they mate is the male sea turtle gets on top of the female sea turtle in the water. And sea turtles breathe air. They're not like fish. They breathe air. And so what can happen is you can get multiple sea turtles, male sea turtles on top of one female sea turtle. And if they get too many, they can actually drown the female sea turtle. Like that is a thing that happens. And I'm like, oh, that's really awful. So sea turtle mating season is kind of messed up. Now, I mean, I didn't get the best images of the sea turtles because the sea turtles are mostly doing like ocean stuff, which means that you don't get to see them that often because, you know, they're in the water. However, I did get some pictures of them outside of the water. I can show you. I could show you some of those. Let me see if I can find it here. I just got to find you a good sea turtle picture. Where is a good sea turtle picture? Here we go. So here we go. Add. So that's a sea turtle. That's a sea turtle. And yeah, the sea turtles were pretty awesome. The other thing is that what is it? So sometimes we were snorkeling around and the sea turtles were like swimming around, you know, just around us, right? They were just hanging out. And that was really cool because the sea turtles are super ungainly on land, and in the ocean they just move like nobody's business. They got all sorts of you know, they are super agile and super athletic, and it is pretty awesome. So yep, I quite like the sea turtles, but I like the sea lions better. So yeah. All right. Okay. So now we've got our next thing here. So, all right. They've got the question here. You didn't tell Trooper Proctor anything about the officer questioning my client, correct? And Lally says, objection. Court says, I'm going to see counsel at sidebar. So the court says, so are you objecting to the argumentative nature that the question began with? Like, Judge Cannone, you're supposed to let Lally tell you why he's objecting. You're not supposed to object for him. You are not the lawyer. The lawyer is the lawyer. And so you've got to let the lawyer. You can't do it for him because then, if you do too much of that, it could be a reasonable apprehension of bias thing, right? So, yeah. So are you and this was for Jackson. So are you objecting to the argumentative nature that the question began with? Except it was Lally objecting, and Jackson says, that's got to have been Lally saying yes. Court says, okay, you can't do that with all the evolving. The Commonwealth didn't object until now, but now that they have objected, the argumentative nature of these questions, the objection is sustained, but you changed it into impeaching her with a prior statement, correct? Okay. So if there's continued objections about the argumentative nature, it'll be sustained, but if it's strict impeachment, you have to ask the question again. He says, I'll rephrase it. So, yeah. So basically just, you got the form wrong. I don't like that she's providing the objection there. All right. So now we have, and prior to January 29th, you didn't know any of these names. Is that correct? No. And you learned of them subsequently. Is that correct? Yes. And now they go to sidebar. So my question is, the court's like, wait until everyone's here. Oh, I'm sorry. So my next question is how she knows. And then this sort of gets into that area of not only Mr. Carney, Turtle Boy once again enters the chat, but this witness also had a visit from a defense investigator in which the defendant was in the car parked outside of her house at the time. Was it that the defense investigator sort of pushed his way into the home with her parents to try to speak to her at one point during the pendency of this case? Mr. Jackson says, Your Honor, that is true. First of all, I suspect that isn't true. First of all, there's no male defense investigator who has ever approached her. We actually did have an investigator, a female, knock on the door, have a very polite conversation with the McLaughlin parents, who said that she would rather not speak with us, and we left, which is our obligation and actually would be within courts as I understand. So nobody tried to push their way in. I don't know where Mr. Lally is getting this other than the witness, and she wasn't even there. We never made contact. Court says, so I guess I'm a little confused as to, you said your next question is going to be what? She says, how she became aware of these names after the fact. I thought she testified she saw it on the news. That's what she did say, says Mr. Jackson. Mr. Lally says, again, I don't know that the news is necessarily Channel 5, Channel 4, or things of that nature. Court says, you brought it up. I'm going to let you lead through what do you suggest, Mr. Jackson? Mr. Jackson says, I don't think this has any, if this is the Commonwealth's way of trying to sully the defendant, court's like, no, I'm asking for suggestions on how you brought it up about how she learned knows these names. She's testified to it and the fact that she watched the news. That was on voir dire. That was voir dire. Mr. Jackson says, and I think he should be able to lead her and say, well, that's why I asked for suggestions. Is it true that you learned this on the news? That was your testimony. And leave it at that. Court says, I'm not going to let you get into the Carney stuff through this witness. There may be other witnesses, but not this witness. You can lead her what she learned by the news broadcast. If it was social media news, that's fine. Understood. I actually think Judge Cannone was relatively fair there because she could have, if she really wanted to be a dick, she could have let the witness go into Turtle Boy there, which, she didn't, so good. All right. So next up, this is still day 11, I believe. Day 10. I think we're probably, just because of time, we're probably going to get through day 10, and then we're going to pause, and we're going to start up on what do you call it? We're going to start up on Friday and resume. So that's kind of my thinking. We've been going for 3.5 hours. And yeah, so we got a bunch more to do with day 10. But yeah. Runkle, you got to pick. Either she can't ask what the objection is or she can't suggest the answer. Fair. Yep, Friday. That's the plan. So, all right. So they've got a sidebar here, and the court says, maybe it'd be better if I did it over here. I wanted to interpose an objection to, and the court's like, yeah, come over to the sidebar. So what are you doing? He says, I didn't have ample opportunity. I just don't know if you're showing photos or you're describing the photos. And he says, no, I'm going to cite a case. That's what I'm going to do. Okay, I'm just going to cite a case. Okay, that's fine. May, Your Honor? He says, okay, as it relates to the 4 exhibits that the court deemed were not admissible because of a violation of Rule 14, I wanted to elaborate just very briefly on her, or elaborate very briefly on her objection. Elaborate, what the? So, they continue arguing Rule 14 does not require such disclosure when the exhibits are used for impeachment only. So, continuing along on that argument. Yes, we read that. I thought that was absolutely bizarre, to be honest, but it is what it is. All right. So they ask for reconsideration on those exhibits, and the court's like, yeah, that's denied. All right. So now they have the view. And yeah. So this is all public things, discussion outside the hearing of the jury. So where is the next sidebar? I think I've got that here. 118. Skim. All right. So they have, as far as the information that firefighter McLaughlin provided, that comport with what you were observing as far as the injuries to Mr. O'Keefe, and then objection. Sustained, you can lay a foundation. And he says, now, as far as, again, the injuries that you observed to Mr. O'Keefe in the back of the ambulance were what? It was bruising of the right eye and the scratches on the forearm. And what, if anything, did firefighter McLaughlin indicate to you had been told to her? That someone said she had hit him and he was last seen. Objection, move to strike. Sustained, that will be stricken. The objection here is, it's a hearsay objection, right? Someone said she'd hit him. No. You got to get that in through somebody who heard it, not a rumor, not information and belief. And Mr. Lally says, may we approach, Your Honor? Okay. And he says, Mr. Lally says, so it's hearsay, but it's not for the truth of the matter asserted, Your Honor, but for the state of mind of this witness as far as his treatment and diagnosis, as far as receiving the information not in conformity with what he's observing on the patient, and then seeking more information. So what Lally is trying to do here is Lally is trying to say, listen, this super prejudicial thing, we want to get this in for narrative to explain why he is acting the way he's acting. He doesn't actually, what he really wants to do, though, is he wants the jury to hear this, right? He wants the jury to hear this super prejudicial hearsay. So the court says, so you have to lay a foundation for that. Mr. Lally says, I think I did as far as what his observations were. The court says, not sufficient. And he says, if I don't have the statement, I can't ask him if it comports with what he's observed. Court says, Mr. Yannetti, well, what do you say, Mr. Yannetti? And he says, well, first of all, I have a question on the relevance of his state of mind as it pertains to the issues in this trial. Who cares what he was thinking? Correct. And, I think it's just a backdoor way to get in some types of hearsay corroboration of Ms. McLaughlin's testimony. Yep. That's exactly what that is. Mr. Lally says, corroboration. The jury's already heard from Ms. McLaughlin as to what the statements were. We've already heard those statements as related by two other witnesses separately. The problem is that they've got a lying pack of liars here, and he wants to get this in through somebody who doesn't seem like a lying sack of shit, right? So, yeah. And Rob Price, we're good. You don't need to worry. Hope your vacay was all that you wanted and more. I'd be sending more, but life is still kicking me in the nuts, and paying for physio isn't cheap. $110 a visit. I'm going to reiterate. If you are not in a good place financially, do not send me money. Do not. As much as I like money, right? I mean, I don't hate money. Money is great. But for, if you're not in a place where you can spend like luxury money on frivolous things, then don't, right? Like, come on. So when somebody says, hey, I'd like to send you more, but my finances are not good. Exactly what I want to hear, right? Like, don't send me money if your finances are not good. 100%, right? So, yeah. Okay. So the court says, so what is it exactly? It's a good time for a lunch break. What is it exactly that you want to ask him? I want to ask him what he was told as far as what firefighter McLaughlin learned from this person. Court says, and why do you say that's not hearsay? Again, the follow-up question that I'd like to ask about is whether or not that explained to him what the injuries were that he observed were purportedly what he was observing. The court says, for what purpose, though? Lally says, again, I think it goes to his treatment in relation to Mr. O'Keefe and how that was handled. And who the fuck cares about, like, his treatment, right? So, yeah. Court says, what do you say, Mr. Unetti? Well, I say that, we haven't received any notice that this witness would be offered as an expert witness. I think there's been a lack of foundation in terms of his qualification to give an opinion of the status of the injuries and whether they comport with what he's viewing. He's not an expert pathologist, or he hasn't been qualified in any way. So I'd object on that basis as well. Of course, isn't this what you all put in through another paramedic that I did tell Mr. Jackson he needed to lay a different foundation? All right, we'll take a lunch recess. When we come back, you can argue it to me. So the sidebar ends with the promise of more sidebar. So, yeah. All right, they vanish, and then they come back, and the next sidebar is... All right. Mr. Unetti says, Your Honor, may we approach sidebar briefly? So this is the question. So in terms of the only commentary that you heard with regard to her feelings or questions regarding John O'Keefe, it was the statements that you heard repetitively over and over and over again. Is he dead? Is he dead? Is he dead? Is he dead? That was some of the things she was saying, yes. So sidebar. Whereupon there was a sidebar conference as follows. My next and final line of cross-examination will be with regard to the injuries to his arm that this witness testified about. And the reason I'm approaching sidebar is I'd like to show him the autopsy photo that the court has previously seen, which depicts the injuries he's described. Given the sensitive nature of it, I didn't want to display that in open court without getting the court's permission first. So that is exactly what the... that's exactly what the, the thing is there. So, yeah. I got to say, I learned from EDB. Like, I learned, when I looked at sort of who I wanted to be like, it was like, no, that's where I want to be. So I, and like, I'm not like flooded in super chats such that I can only talk to people who send super chats. I want to, and I want to talk to people who just like have questions. Right. So, yeah. All right. What does the Commonwealth say? Mr. Lally says, as far as that photograph, I would anticipate something along, she says, speak up. I'm sorry. I'd anticipate something along the same lines that I'd be seeking to introduce at a later time. Is this what he saw, though, in the short time in the ambulance? That I don't know. Well, he saw those injuries, whether they had more blood on them or not. The court says, these are obviously going to come into evidence. They are. I'm just not sure this is the right witness. Mr. Unetti says, well, I want to explore that, Judge, and if I fail to lay a foundation, I'll mark them for identification. But I want to show it to him to see if he'll identify it. Court says, why do you need 3? I don't. Okay, I'm going to mark 1 for identification now. If he adopts it, you can put it in through him. Great. If he doesn't adopt it, you can't. I understand. Mr. Jackson, please come back. What is the letter for ID? The court reporter says, that will be N for ID. N for Nancy. So, yeah. Redford says, no cocaine in hot tubs here. I don't even own a hot tub. I also don't own any cocaine, just in case people were like, wait, by omission. But yeah. So, court says, thank you. Do you intend to put it up on the screen afterwards? I would, yes. All right, so get him to adopt it. Yes. All right. If they really wanted to be a dick, they could have been like N for Nancy. Just, yeah, that would have been funny as hell. Might have gotten them in trouble. I get why they wouldn't do it. So, yeah. All right. So, let's see. And then we have another sidebar here. So they're showing him the picture of the arm. Just show that to him. Just show him what needs to be cropped off. Oh, yeah. So I think we'll skip this one. It's just they do some discussion of how to mark this. It's electronic. So skip that over just for timing. And we shall jump to Zoom. All right. So, what is it? They want to introduce in the next exhibit. So both reports through this witness. Yes. Is there any objection? And he says, I'll just take a look through the DA's copy. Your Honor, may we approach? And he says, Your Honor, my only issue is that he's testified that the engine report is not his. He did not write it, so there's no authentication for that. I do not object to his own report going in. The court says, is it the same that you gave to the last witness? Only to refresh memory. I understand. I don't think anybody realized there were 2 separate reports before that. Who authored the other report, Mr. Lally? Do you know? And he says, I believe it would have been, I'd have to look at it, but either Lieutenant Woodbury or firefighter Pock, something, one or the other. All right. Would this witness know? I think I have a feeling that he might not necessarily offhand. All right. So I'll allow his report in. If you need to call Woodbury for just that point, Mr. Lally says, I don't think so. All right. Before you do, do you want to mark the other report for identification, Mr. Lally? The first part? No. So 2 reports, and they only get 1 in because it's his report. The other one, they're like, yeah, we don't have the witness. So, yeah. Mr. Squirrel doesn't believe you're live. Can you say hi? Hello, Mr. Squirrel. I am live. So, yeah, we're all good. All right. Let's see. Next one here is at 196. There's a little bit too much cocaine discussion in my chat right now. I'm like, okay. People saying, when I worked as a lab assistant in college, I had access to coke that they used to inject into crawfish to study their reaction. I bet the crawfish enjoyed that better more than some of the other studies they might have gotten to. What is it? Honestly, with your back problems, a hot tub is not a frivolous purchase. So I am told my doctor cannot write me one as a prescription. I've already tried. The problem with a hot tub is that they're insanely expensive. But what is it? I do love. What is it? I do love a hot tub, especially in Alberta winters. I will just say there is something lovely, something really, really nice about a hot tub in like 30 below weather. And the reason why is because your head is staying cool. And so you're sitting there in the hot tub, but you can stay in there for basically forever because you, what do you call it? You're cooling off as you heat up. But the other thing is, it's also really fun to be able to do things like, you dunk your hair in, and then you pull your hair up into a line, and you sit up, and because it's freezing, it just freezes like this, and you're sitting there, and you can do all sorts of you can do all sorts of fun things. So, yeah, I just the problem is, though, having a hot tub is really expensive, especially in the winter, because you have to keep it heated so it doesn't freeze, and 30 below weather. It's really, yeah. So, I don't know that I could afford a hot tub. you know, I don't see how that would make financial anything. So, all right. So, sidebar conference concluded. Mr. Unetti says, with your permission, I'll repeat the question. And, so the sidebar here was, what is the objection? Your Honor, essentially, counsel is just reading from the report without any sort of indications from the witness that his memory is exhausted as to that or what he told. He's reading Trooper Proctor's report and asking him if he agrees with it. Okay, the objection is overruled. You can do that. That should have been sustained. That should have been, yeah. JMR says there's a compromise. They have bathtubs with hot tub features. So I will say, what do you call it? One of our dreams, one of our sort of eventual goals. So this house that I'm in right now, this house right here, is it was built in the 50s, right? It's a post World War II house. And I mean, it's not a bad house, but it's also not a great house, right? It's showing its age. It's a little small. It's all these things, right? So one of the goals is to eventually, but the thing is we got a great location, right? We got a great location. And so eventually I'm hoping to knock this house down and then build another house on this lot, right? On the same space. And if we do that, I'm going to put some nice bathtub features in so that I can soak my back. And, that's kind of the goal. It doesn't need to have like the jacuzzi jets and so forth. It just needs to be big. I just want a big tub. So I thought you're going to get Mrs. Runkle a hot tub. No, I'm going to get her a sauna. So that's the goal. Is I want to get her a sauna and set it up on the land. So, yep. All right. One more for day 10, and then we will wrap it up here. All right. So, what is it? There's a sidebar conference. The court says, what's Tony's name? Call him over, please. Can you call him over, please? Court officer says, yes, Your Honor. And then there is some sort of juror issue. And Mr. Lally, why did you want to come to sidebar? Your Honor, just in regard to scheduling. I know the court. I'm fine to keep going with the next witness. Will be Lieutenant Gallagher. I remember the court said something about sometime at the end today. Court says, a jury's never going to mind leaving a few minutes early on a Friday. Is that what you'd prefer to do? Mr. Unetti says, that's perfectly fine. I think that would be a really, yeah, really nice thing for the jury to let them out on the Fridays. So, yeah. What is it? I think rather than starting with his testimony, and the court says, okay, so I'm going to let them go now. You all stick around. So jury gets kicked out. They get kicked out early. I'm sure they do not object at all. And picturing the house building sequence from the Red RDR2 epilogue. I haven't actually played RDR2 yet, but with Runkle, Kurt, and Rob instead of John, Charles, and Uncle. Fair. Yeah, that would be good to invite people out. Also, I am certain Rob is not watching this. because Rob is too busy right now. He does not have time. So I am getting ready. Rob does not know when his wedding is. He has not figured that out. But I am getting ready to for his eventual wedding. And one of the things that was discussed is Julia, do not timestamp this part. One of the things that was discussed is a Nerf war at his wedding. That there might be a Nerf war. Rob will catch the replay. Probably not. So, and also, Rob, if you are watching the replay, stop watching the replay. So, I may have backed something on Kickstarter. Will you wear the tie at his wedding? Probably. I may have backed a Kickstarter. And so let me just find you an image of what the Kickstarter is for. Because so they're planning on having a Nerf wedding or like a Nerf fight. And so I need to share the screen here. Share screen. Now, I'm not buying this assembled, so when you see the price, that's not the price I paid. I paid a price for a kit, not the full assembled version, because the full assembled version has an insane price, and I can tell you I cannot spend that on things. But Celsius. With like a backpack. Like I backed this. And what is it? So what I need to do is I need to find a way to hide this in the wedding venue. And also, I'm going to end up making a video about this. I bought this in part so that I could do a legal discussion of it. It's $5,000. No wonder you're assembling it yourself. Yeah, and what is it? Instead of that, I'm spending like $500, so it's way cheaper. So I got to figure out a way to hide it on scene. And then at like a pivotal moment when the Nerf gun is starting, I am going to pull out the Nerf chain gun. And I am gonna So yeah. And that should be fun. Yeah. I've got ideas for how to make this work. I don't yet have a 3D printer, so I got to get a 3D printer for this too, or find one or borrow one or whatever else. But yeah. Anyway, that is going to be fun. So yeah. All right, let's cover super chats. So she's trying to prove she's a real judge now. Yeah. Looking forward to more stories. We've got lots of stories. Everyone knows that elves are capable of being in more than one place at a time. Confess thy sins. Story time. Really, let's see and hear the story. More story. Story. Take us to Galapagos without the seasickness. Yeah, the seasickness was not good. Does the court reporter have a shorthand for judge size heavily? No, they usually omit that kind of thing. Ian BPPK, thank you for being a member. So you could swim with them in the ocean, but I can't swim with them at the aquarium. So unfair. Yeah, fair. Gains the Tide, please like for a late belated birthday gift for me. Happy birthday, Tide. Welcome back. We missed you. Thank you. Thank you for 10 gifted memberships. Mega's autistic, caught up on 2.35 speed. Glad your trip was good. It was amazing. Glad you're back. I am glad to be back, although I was glad to be there too. So Galapagos Stories, welcome back. Have a Merry Christmas, everyone. Merry Christmas. These pictures brought to you by Only Turtles. I'm way behind playing catch up, but thank you for all the poopy pics. Fair. RIP Vince Zampella, Call of Duty creator, Ferrari enthusiast. Yes, I heard about that. Oh God, please no Kurt. New statements of his coming to light that are big ick, and I would not let this person around my 16 to 18-year-old daughter vibes. Don't know what that's about. I volunteer to help smuggle in the Nerf war crime. I'm gonna figure that out. I guess something else I'll show you before we go. Let me just find one more picture before we go, just because, kind of got to. Let's see, where is it? And here we go. Here's a good one. And there we go. Nope, that is the wrong thing. There we go. So, this is not a turtle. This is a tortoise. And the tortoise. So this tortoise is at a little farm, and the farm is what do you call it? The farm is right next to like the tortoise reserve, and they what do you call it? So what they did is they got permission to basically, like, the tortoises wander into the farm, and the farm mostly grows like tree fruit. And so the tree fruit, the tortoises can't get to it. So it's all good. Now the farm does grow some stuff that that is on the ground, but what they found is that they can actually just put a little bit of bamboo on the ground, and the tortoise won't cross the bamboo. So they what do you call it? The tortoises just do their, stay out of the thing, and they just sit there munching on the grass and all of that. But yeah, they are lovely, and they are they were pretty chill about people being nearby. But if you get close, then they put their head in their shell. Is this the last stream for the year? No, we're gonna do one on Friday. That's the plan. Now, one of the funny things is that when they retreat into their shell, they actually make kind of a hissing noise. And the reason why they make a hissing noise is that they're actually breathing out so that they can make space under their shell. So they kind of make this hissing noise because they breathe out and pull their head in so that they can, so that they've got the space. Now, one of the other really interesting things, so when the tortoises are in mating season, male tortoises get into fights, but male tortoises have the best way of fighting of like any animal in the animal kingdom that I'm aware of. Do I know how much it weighs? Probably like 600 pounds. They're big. The male tortoises, when they want to fight, here is what a tortoise fight looks like. The two tortoises walk up to each other, and then they both lift their necks as high as they can. And whichever tortoise can put its head up in the air higher than the other tortoise is the winner. So purely the only thing they do is they just like, I can reach higher than you can. And it's like, they don't have to fight. They don't have to anything. It's just like, I am bigger than you are. And yes, they literally have a measuring contest. Honk Banana, no, I still see your chats. So, yeah. So they literally have a measuring contest. I feel like there are guys at bars who do this, but they do it metaphorically. The other thing about the tortoise fights, like the tortoise, apparently sometimes they win because they're just on the hill, like on a, they're just a little. But it's so weird that they're just like, yep, I am just a little taller than you. So yeah, I also, has anyone else seen Invader Zim? I'm sure some of you have, right? And so the tortoises literally have like the almighty tallest, because whichever tortoise is the tallest is the king, is the winner. So I'm like, the tortoises literally have the almighty tallest, and I am just like, so yeah. Anyway, we'll wrap it up here. I think that's all the super chats. I will see you guys on Friday, is the plan, unless something comes up. If something comes up, I'll let you know. But yeah, now I kind of want to go watch some Invader Zim, and for some reason, my nose is running. I've got some sort of allergy thing, so I gotta, go blow that, and you don't need to see that on stream. So I will see you guys all sometime soon. And random, if you want. All right. So let's see. Good night, all.